substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this agreement?
No, sir.
Has anyone promised you anything in return for your agreement other than negotiate plea bargain that you made?
No, sir.
And you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And you've given up all your trial rights, which are listed on page 1 of this agreement that you've signed?
Yes, sir.
And you understand that you're waiving all potential defenses?
Yes, sir.
And what is your plea?
No contest.
This is state's agreement.
Yes, Your Honor, it is.
I'll accept your no contest plea, withhold adjudication to the amended charge of resisting with violence, 36 months probation, $40 per month cost of supervision, $615 court costs, forfeit the motorcycle, 1 session of the victim impact panel, and complete a basic driver improvement course. Any questions about that?
No, sir.
Judge, I would ask the cost of supervision be waived again. This one is a financial hardship. They have suffered greatly, great losses directly related to this case. I did speak with Mr. Berry about this, and I don't know that probation has an objection under the circumstances.
We don't object to it.
State,
No, Judge.
based on no objection from the state, probation, waive cost of supervision. All right, go over and step over to probation. Once they're clear, Mr. Collins, talk to them about it, and you've got 30 days to appeal the judgment and sentence. I don't think I need fingerprints, so withhold on it.
Thank you, Judge.
This is a downward, or this is not a downward departure, this is a guideline
Guidelines.
sentence.
It is a guideline sentence.
First one.
The next case I have is Chase De Roberto in 23 CF 2489 and 23 CF 2496. Mr. De Roberto is present and approaching. We have reached an agreement when they approach.
Yes.
GTI is directly behind you. Mr. De Roberto in 23 CF 2489 is entering a no contest plea. It will also resolve 23 CF 2496, entering into the pretrial intervention program listed in the agreement provided to the court.
Y'all approach, please.
Yes.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, you're here in 23 CF 2489 and 23 CF 2496, a total of 3 counts of child abuse without great bodily harm. I've been handed a plea and sentencing agreement. The negotiated settlement between the state and you would be pretrial intervention for 24 months in 23 CF 2489. And the state would be then dismissing 2 counts in 23 CF 2496. Is that your understanding of the agreement?
Yes, sir.
All right. And have you gone over the pretrial intervention program agreement with your lawyer?
Yes, sir.
Did you understand all the terms of that?
Yes, sir.
Okay. You understand if you complete the pretrial intervention program offered to you by the state that your case would ultimately be dismissed.
Yes, sir.
And does the state want to put any reasons on the record as to why this offer was given?
This is a difficult case for them.
All right, Mr. Roberto, did you go over the plea and sentencing agreement with Ms. Merrifield?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you currently suffer from any mental health issues or concerns?
No, sir.
Has anyone forced, threatened, or pressured you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the pretrial intervention and the dismissal of the charges? Has anyone promised you anything to
No,
get
sir.
you to plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up all of your trial rights, which are listed on count 1 or page 1 here?
Yes, sir.
Do you understand that you're waiving any potential defenses?
Yes, sir.
Do you understand that if you're unsuccessful on your pretrial intervention, you'll come back for sentencing?
Yes, sir.
And since you're only pleading to 1 count, you're looking at potentially 5 years in the Department of Corrections if that were to happen.
Yes, sir.
Do you have any questions about the terms of the pretrial intervention?
No, sir.
What is your plea?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. You're to complete pretrial intervention to a term of 24 months, $667 court costs, $150 cost of prosecution, $40 per month cost of supervision, no unsupervised contact with minors, no contact with the victims. Those are JC, LN, and JB. So it's all 3, even though it's only 1 count you've pled to. Continue your current counseling, anger management, evaluation, and treatment, and if recommended. If you've previously completed that, you can show proof. Do not foster any children, and show proof of forfeited foster license. They'd have an announcement as to the 2 counts of child abuse in 23 CF 2496. All right, step over and talk to probation. They'll be handling your pretrial intervention program. And you have 30 days to appeal the judgment and sentence of the court. I think Mr. Berry probably needs this back. Thank you, Mr. Berry.
Judge, the next case I have is Leah Feeback in 24 CF 2768. Ms. Feeback is present and approaching. We've reached an agreement, if I may approach. And Ms. Feeback in 24 CF 2768 is withdrawing her previously entered not guilty, entering a no contest to pretrial intervention. The terms are addressed on the agreement, Judge.
Ms. Feeback, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Your Honor.
Okay. Can you state your name and date of birth, please?
Leah Adriana Feeback, January 2nd, 1989.
All right. You're here in 24 CF 2768. You're currently charged with leaving the scene of a crash with injuries. It's a third-degree felony, punishable up to 5 years in state prison. Do you understand that? All right. I've been handing a plea and sentencing agreement that calls for you to enter a no contest plea, and you'll be given pretrial intervention from the state, term of 12 months. Restitution is $80.
It is, Judge, and that has been confirmed.
Want to make sure that wasn't a typo.
Yes, sir.
$40 cost of supervision and a basic driver improvement course. Is that what you want to do today? Is that the state's agreement?
Yes, Your Honor.
All right, thank you. All right. Have you gone over the plea and sentencing agreement as well as the pretrial and intervention agreement with your lawyer?
Yes, Your Honor.
Did you understand those documents?
Yes, sir.
Did you have any questions about them?
Sir.
Okay. Are you satisfied with your lawyer's advice and representation? Could you get a little closer to that mic? You're kind of soft.
Yes, sir.
I can hear you, but I'm just worried that the record is not picking you up. All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the pretrial intervention in order to get you to plead to this?
No, sir.
Okay. And do you understand that if you enter a no contest plea, there won't be a trial of any kind? Do you understand that you're giving up your trial rights, which are listed on page 1 of your plea and sentencing agreement? Do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
You understand that if you are unsuccessful with the PTI, pretrial intervention, that you'll come back and you can be sentenced up to the maximum, which would be 5 years in state prison. All right. Do you understand if you successfully complete your PTI, that your case would ultimately be dismissed?
Sir.
Okay. All right. And what is your plea?
No contest.
I'll accept your no contest plea to leaving the scene of a crash. You'll have 12 months pretrial intervention, $150 in court costs, $150 cost of prosecution, $80 in restitution. Do we know who that's to?
It's going to be to Trooper.
ASA, listen, I think the discussion was to pay it through the diversion program and not directly to the, because of the
Correct.
conflict there.
It's the trooper that was
Yes.
injured?
Yes.
Okay. So do you want to just pay it through the rest of
Through
the
the program.
PCI, and I'll get them
Absolutely.
the information?
Yes.
Okay.
I just wanted to make sure that was
Thank you,
spelled
Judge.
out. I didn't realize it was the trooper. So $80 doesn't really cover a whole lot, but I guess that was it. All right, $40 per month cost of supervision and complete the basic driver improvement course. Ms. Feeback, I don't need your fingerprints, but I need you to talk to probation once they clear up over there. You have 30 days to appeal the judgment and sentence of the court.
And Judge,
You provided a copy of the score sheet.
I have not.
not for PTI.
I think they-
It's still a plea. Right. If you could get that to Mr. Berry. Okay, that's the next one. Yes.
And Judge,
There's
I
a guideline
just,
sentence.
yes, give you an opportunity to sign that.
Next
Judge,
case.
the next case I have is Madison McKenzie, 24 CF 1935. I just handed the court a plea in absentia to a misdemeanor for Mrs. McKenzie's case. And there is a signature block on the back page, Judge. Ms. McKenzie is withdrawing that previously entered not guilty plea in 24 CF 1935, entering a no contest. It is an adjudication and Prince would be during the term of her supervision.
Does JCS usually handle that well?
Yes, Your Honor, we have, I assist with that, so I will have her inked prints done and sent to JCS, because it will be for JCS supervision.
All right, so just to make sure it's clear on the records, we've had a couple recently where there's some confusion as to what type of probation they're on, and we had to go back and look them up, so I just want to announce it on the record.
Sure.
This is Madison McKenzie, 24 CF 1935. She's currently charged with sale, manufacture, and deliver, second-degree felony, and count 2 is possession of a controlled substance. The term of the plea to a misdemeanor in absentia. Thank you for getting it right, that it's absentia, not abstentia.
Yes, sir.
Count 1 would be dismissed, is that correct?
Yes, Your Honor.
All right, and count 2 is a plea to a lesser included offense of possession of marijuana, first-degree misdemeanor, calls for 11 months, 29 days probation with Judicial Correction Services, or what we call county probation, $55 cost of supervision pursuant to the contract with JCS, $515 in court costs, substance abuse evaluation, any recommended treatment, consume no alcohol or controlled substances without a valid prescription. The court wouldn't have any objection to a hardship license if otherwise available. Is DHSMV making y'all do that in all these cases now? It has to be
Yes.
announced on the record?
Absolutely.
And as a condition of her probation, she'll have to have her fingerprints submitted. This would be
Correct.
JCS, Mr. Barrios, so you're looking around. And does she have the information to appear with JCS? And get
She
that?
does. We have the QR code we're sending to her, and we're going to walk her through it.
Okay, thank you.
The last case I have, Judge, is under my name. Kristen Roberts is present and approaching.
Go ahead.
We just have one last change, Judge, that we are making. Yes, just initial there. Perfect. And we've reached an agreement, Judge. May I approach? And Ms. Roberts in 24 CF 1259 is withdrawing her previously entered not guilty and entering a no contest plea to the terms provided. It would be a withhold of adjudication.
All right, Ms. Roberts, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Kristen Roberts, 9/10/1996.
All right, Ms. Roberts, you're here in 24 CF 1259, charged with 1 count of tampering with evidence, which is a third-degree felony punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been given a plea and sentencing agreement that calls for you to plead no contest, receive a withhold of adjudication, 36 months probation, 50 hours of community service costs. You can buy out the community service at the statutory rate, substance abuse evaluation within 30 days, recommended treatment to start within 60, random drug testing, and no contact with Larry Leonard. Is that your agreement?
Yes, sir.
Is that the state's agreement?
Yes, Your Honor.
All right. And have you gone over this sentencing agreement with your lawyer, Ms. Merrifield?
Yes, sir.
And has she answered all of your questions?
Yes, sir.
Did you understand the agreement?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to get you to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the negotiated
No, sir.
plea bargain to get you to plea?
No, sir.
Okay. You understand that if you plead no contest, there won't be a trial of any kind?
Yes, sir.
You understand you're giving up all of your trial rights, which are listed on page 1 of your agreement?
Yes, sir.
You understand you're waiving all potential defenses that you may have?
Yes, sir.
And what is your plea?
No contest.
Accept your no contest plea to the tampering with evidence charge, withhold adjudication. 36 months probation, $40 a month cost of supervision, $615 in court costs, 50 hours of community service. You may buy those out at the statutory rate, like I previously mentioned. Complete a substance abuse evaluation within 30 days and begin any recommended treatment within 60 days. Submit to random drug testing. If you're positive for anything on the random testing, that would subject you to potentially a violation of probation, where you could be sentenced to up to the maximum of the 5 years prison. Do you understand that?
Yes, sir.
All right. No contact with Larry Leonard. You know who that is, right?
Yes, sir.
Okay. Any other questions?
Judge, I would ask the cost of supervision be waived. Ms. Roberts did lose her job as a result of this charge, and she has been unable to obtain employment, and this has gone on for quite an extended period of time. I don't believe that probation had an objection under the circumstance.
State have any objection to that?
No, Your Honor.
Based on no objection from the state in probation, I'll waive cost of supervision. All right, step over and talk to probation, Ms. Roberts. You have 30 days to appeal the judgment and sentence. This was a guideline sentence.
Your Honor, on that 30-60 on the evaluation, I promise you we'll get them down there. I can't tell you that they will see them in 30 days.
Okay, well, obviously it would be a violation if it's to do no fault of her own that she can't get the evaluation. All right, Mr. Crawford.
On behalf of Randy Reagan, we discussed this case via Zoom. May I approach, Your Honor?
Yes, sir.
I'm sorry, yeah.
Are you coming too? I didn't know if you were.
We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car,
motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out Amanda's.
I will continue the case one last time, and it's my understanding there's just some car data that still needs to be supplied. Once that's received, we'll have the motion to suppress hearing if it's still needed. As I stated up here at the bench, that's to be set and heard before our next pretrial. Okay.
And when's the next pretrial date?
That'll
Ron?
be April 30th. So your dates are somewhat limited as to when we can have that heard, so make sure you get it done before we run out of times.
Yes, Your Honor.
All right, so Mr. Reed, we'll see you back on April 30th at 9 o'clock. That is the in-custody pretrial conference date. Ms. Leon, if you said this is over your objection, if you want to make any sort of objection, you
I was
certainly
going to
can.
ask the court to let the record reflect that it's over state's objection.
I understand that, and that's why we've talked about how we can get these motion issues done faster, especially when it involves motions to compel and relying on agencies to turn things over to y'all so we can get it done faster. So I understand the state's objection, but I'm going to grant the last continuance. And we'll see you back on April 30th.
Thank you, Your Honor.
Thank you, Mr. Crawford. All right, thank you, Mr. Crawford. Mr. Riasti.
Morning, Your Honor.
Morning.
Joseph Riasti for Marcellus LaKelly McWilliams III, who's present before the court. It is
Everyone's been
LaKelly,
saying
not
likely,
likely.
so.
Yes. 2024 CF 1725, if I might approach this, we've reached an agreement. To a lesser included offense.
All right. Sir, if you raise your right hand, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
Marcellus LaKelly McWilliams.
All right, sir, you're here in 24 CF 1725. You're currently charged with as aggravated threat or as aggravated assault with a deadly weapon, which is a third-degree felony and punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state attorney's office that would call for the case to be misdemeanor assault, misdemeanor second degree, with 6 months of probation, no contact with the victim, and some costs. Is that what you want to do?
Yes, sir.
All right. Is that the state's agreement?
It is, Your Honor.
Okay. And have you gone over this agreement with your attorney, Mr. Riasti?
Yes, sir.
And has he answered all of your questions about it?
Yes, sir.
Did you understand the agreement?
Yes, sir.
Did you sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or
No, sir.
concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the negotiated plea in order to get you to enter that plea?
No, sir.
And do you understand that if you enter a no contest plea, there won't be a trial of any kind?
Yes, sir.
And you'd be giving up your trial rights, which are listed on page 2 of the agreement that you've signed?
Yes, sir.
All right. Do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
All right. And what is your plea?
No content.
All right. I'll accept your no contest plea to the second degree misdemeanor assault. Terms are adjudication of guilt, 6 months probation, no contact with the victim, Nelsina Warren, $270 in court costs, $150 PD fee. The state, have y'all talked to Miss Warren?
We have, Your Honor, we have communicated. She's in agreement with that resolution.
Okay.
Your Honor, I'd ask that the court consider waiving the cost of supervision even with this short term, as Mr. LaKelly McWilliams III lives in Pensacola and works in day labor.
Were you appointed on this case, Mr. Rios?
I was, Your Honor. That's why the $150 is.
Okay. All right, I'll waive cost of supervision. Is this going to be with DOC, though?
I understand, yes.
Yes. All right. Department of Corrections will supervise you, Mr. LaKelly McWilliams. Go talk to them real quick, and they'll set you up with your probation. I think I still need fingerprints. It's an adjudication, even though it's a misdemeanor, it's assault, which I believe is enhanceable. And then you have 30 days to appeal the judgment and sentence Mr. LaKelly McWilliams. Obviously, there's no score sheet because it's a misdemeanor.
Yes, Your Honor, correct.
All right. Thank you.
That's all I have before you.
Thank you, Mr. Riasti. All right, Mr. Harsher. You're under Henderson, is that right?
Yes, we have Kevin Josie, Dustin Harsher on behalf of Kevin Josie. This is case number 22 CF 1289. Mr. Josie is present and approaching, Your Honor. It's my understanding after communication with Mr. Henderson this morning that there's been a motion for a competency eval to be conducted in this case. My understanding is that there was a previous competency eval ordered by the Public Defender's Office. However, there's no indication in the record of any order that was ever signed or ever done in this case. We're unable to locate that evaluation or that doctor's office. So we'd be moving for a continuance to be able to conduct that evaluation.
Yes.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Josie, 22 CF 1289. It's my understanding that a motion's been filed that will need to be amended, and then I will sign the order regarding the evaluation. Mr. Josie, they're going to have you go talk to a doctor and give us a report back to see if we're ready to go forward with trial. You understand that? This is a very old case. I know Mr. Henderson hasn't been on it the entire time, but he's been on it long enough. This case really needs to get resolved. But if you could make sure you send a courtesy copy of the amended motion as well as the proposed order to me as quickly as possible, Mr. Harsher.
Absolutely, Judge.
All right, thank you.
Do we want to leave this on a tentative date?
Oh, I'm sorry. We're going to put it on April 28th at 9 o'clock.
April 28th. All right, thank you, Your Honor. I believe that's all I have.
All right, thank you, Mr. Harsher. All right, Ms. Dudley.
First one, I have
Justin Diaz. This is Justin Diaz in 24 CF 1499 and 21 CF 2951. We did continue him already to the April pretrial. If we can just set these cases on that date and have him remain in our county jail until this case is resolved. He was the one we had transported back from Walton County.
What are we doing with the cases?
Well, I'm still trying to go through it and then talk to the state, see if we can get it resolved. I wasn't the original attorney. I got it right before this cycle, this pretrial.
You were privately retained for that?
Yes, sir.
purpose?
But I am trying to get caught up quickly so that we can get it resolved.
How long has he been in continuous custody?
He's been
in Walton County, sir, for 3.5 years.
3.5 years in Walton County.
He's been here since July, right? June or July?
Yeah, a month or two.
Yeah. They transferred him back over there and then brought him back. So.
All right, I would suggest everyone is ready to get this, at least the 2021 case over
Yes, sir.
the next time.
Yes, sir.
I know based on the circumstances, I understand Mr. Diaz has a lengthy prison sentence in Walton County, but these cases are very old.
Yes, sir.
All right, April 30th at 9 o'clock for your next pretrial. All right, next case.
Next, I have Joe Fernandez in 23 CF 1605. He also is represented by the Public Defender's Office in several cases.
Someone else on Mr. Fernandez as well?
I do have a written plea agreement for misdemeanor on my case, Your Honor.
On your case?
Yes, sir. And that's the 23 CF 1605.
Russell, what's going on with his other cases?
Judge, for the record, Public Defender has 23 CF 2756, 24 CF 219, 24 CF 644, 24 CF 857, and 24 CF 1128. Judge, we don't have a global offer. We did have an offer on the two oldest cases, and it was 91 and a half months with an offer of 15 years DOC. Best I could tell, depositions were not taken, so at this time, Zeman finding him competent.
That was my concern. I just couldn't remember if we got it back or not.
Yes, so the clerk indicates it's filed in 24 CF 644.
Well, if he's going to plead a one charge, I want to make sure he's not seeking the competency evaluation and other ones at the same time.
Yes, sir.
What I don't see is an order of finding him competent. Who's handling Mr.
I am, Your
Fernandez?
Honor.
Ms. Leone, Mr. Russell, on your cases, are y'all stipulating that I make the determination on the single opinion of Dr. Zeman?
Yes, Your Honor, we will stipulate to that.
You could get me an order, Mr. Russell, on your cases, finding that he was competent based on the stipulation of doing that one, a single report of Mr. Zeman, or I'm sorry, Dr. Zeman, which I've reviewed, where he opined that he was competent to proceed.
Do that, Judge.
All right. Ms. Dudley.
Did you
Yeah.
have a written agreement?
Yes, sir, I did. By my approach.
Mr. Fernandez, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
On the question?
Say again?
Yeah.
Yeah?
Sir.
Okay. Can you state your name and date of birth, please? All right, Mr. Fernandez, you're here in 23 CF 1605, where you're currently charged with burglary of an unoccupied dwelling and petty theft. I've been handing a plea and sentencing agreement between you and the state attorney's office that calls for a plea to a lesser included offense of trespassing as to count 1 and dismissing count 2. It would call for an adjudication of guilt, time served, $270 in court costs, which should go to judgment. Is that what you want to do today?
Yes, sir.
All right. Is that the state's agreement?
It is, Your Honor.
Since this is a burglary case, have you talked to the victim in the case to see if they have any objection?
Unfortunately, Your Honor, we made several attempts to locate the victim and we were unsuccessful this whole time.
This is a 23 case, so it's very old. All right. Mr. Fernandez, is this what you want to do today? Okay. I'm going to be asking you a lot of questions. I need out loud answers so they can be recorded by the microphone that's in front of you,
Let me
Mr.
step up
Fernandez.
a little bit, then.
Say again.
I'm just going to step up so you can hear me better.
Okay. I just want to, well, you weren't responding verbally. That's why I'm saying so.
Yes, sir.
All right, Mr. Fernandez, have you gone over this agreement with your attorney, Ms. Dudley?
Yes, I have, briefly.
Okay. And did you understand it?
Yes, sir.
Did she answer any questions if you had any?
Yes, she
Did you
did.
sign the agreement?
I did, sir.
And are you satisfied with your lawyer's advice and representation in this case?
So far, yes, sir.
Is there anything else you're expecting? Is there anything that you've asked Ms. Dudley to do that she hasn't done for you?
Get me out. He just asked the question. He told, I took an oath, you know.
I got you.
Is there something specific that you've asked her to do that she hasn't done for you?
Get me out, sir.
Does she represent you on all of your cases?
I believe so, yes, sir.
You believe she represents you on all the other cases too? Why do you think that?
You know, coming in here, every
You
time I
understand
came
you're
in here, I
represented by
seen
the
it.
public defender in all your other charges, right?
Huh?
You understand that you're represented by the public defender in all these other charges? All of your other cases that Mr. Russell just brought up.
No, I do. I didn't. No.
Based on that now, are you satisfied with what Ms. Dudley has done as to this one solo case?
Yes.
Okay. Are you currently under the influence of any alcohol, drugs, controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of your negotiated plea bargain to get you to plea?
No, sir.
You understand that if you enter a plea, there won't be a trial of any kind on this case?
This is one charge we talking about, right? Yes, sir.
What is the charge that we're talking about?
Trespassing now, am I correct?
Reduced from burglary, right?
Right. Yes,
Based
sir.
on your lawyer's negotiation with the state attorney, right?
Yes, sir.
Okay. So you understand on that burglary and petty theft, there won't be a trial?
I do understand.
Okay. You understand that you're giving up all of your trial rights, which are listed on page 2 of the agreement that you signed?
Yes, sir. But this is time served, though, right? Like, I ain't got to do no more time for that.
Did you listen when I announced what the agreement was? Did
Yeah.
you read the agreement?
Yes, sir.
Did you understand it?
Yeah.
Yeah. So what's your agreement, Mr. Fernandez?
My agreement is time served.
$270 court
Right,
cost of
$270
judgment and
court cost.
adjudication of guilt, right?
Yes, sir.
You understand that you're waiving any potential defenses that you may have in this case?
I understand all that.
Okay. All right, Mr. Fernandez, I ask everybody all these same questions. It's part of what we call plea colloquy. I'm not sure why you seem to be upset by me asking you very common, easy questions.
Because everybody ain't the same, sir.
Say again.
Everybody's not the same, sir.
Everybody has to be treated the same, though, right?
That's in your world.
Just to make sure that he's sure, is Mr. Fernandez still being held on his other cases?
Yes, sir.
All right, so he's not going to be released based on this time served.
No, he has the other case with the public defender's office.
All right, just want to make sure he understands that. All right, what is your plea, Mr. Fernandez? To the lesser included offense of trespass?
I'm just taking whatever come with it, sir.
All right. How you doing, Ms. Dudley? I think you might need to talk to him a little bit more. I don't think he understands what's going on here.
I'm out of plea. I took my plea already. Now this a deal.
I haven't accepted your plea at this point,
When I did
Mr.
the time,
Fernandez,
I signed
because
it.
you're not answering the questions.
Yeah, 7 goddamn questions, man.
Say again, Mr. Fernandez?
Ain't else to say.
Mr. Fernandez. All right, April 30th from Mr. Fernandez. If he wants to actually enter his plea and answer very simple questions, then Dudley, I'll certainly take his plea earlier, but.
Yes, sir.
That will be all cases, Judge?
Yes.
Thank you, Judge.
And next I have is Cameron Moffett in 24 CF 2479. Mr. Moffett is present. I have a plea agreement to a lesser included and a PTI agreement, if I may approach.
Mr. Moffett, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your name and date of birth, please? Okay. And Mr. Moffett, you're here in 24 CF 2479. You're currently charged with fleeing or attempting to elude high speed, which is a second-degree felony, punished up to 15 years in state prison. But I've been handing a plea and sentencing agreement for a lesser included of fleeing or attempting to elude third-degree felony, punished up to 5 years in state prison. Do you understand that?
Yes, sir.
Okay. And it calls for pretrial intervention, which would last for 10 months. Have you gone over that, the the pretrial intervention agreement with your attorney?
Yes, sir.
Did you understand all the terms of it?
Yes, sir.
All right, so the terms are no new law violations, successfully completed basic driver improvement course, victim impact panel, some costs, and just basically show proof of all that. So that's what you understand the terms to be. Okay. I think you're just kind of tall, and so you're farther away from the microphone, so it doesn't pick you up as easy, Mr. Moffett. All right, and is that the state's agreement? All right, have you gone over the plea agreement and the pretrial intervention agreement with your lawyer, Ms. Dudley?
Yes, sir.
And did she explain everything to you?
Yes, sir.
Did she answer any questions if you had any?
Yes, sir.
And are you satisfied with her advice and representation in this case?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
You suffer from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to get you to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of this pretrial intervention agreement in order to get you to plea?
No, sir.
You understand that if you're successful with your pretrial intervention, the case will be dismissed?
Yes, sir.
You understand if you're unsuccessful in completing the terms of your pretrial intervention, that you come back for sentencing and can be sentenced up to the maximum, which is 5 years in state prison?
Yes, sir.
You understand by entering this plea and doing the pretrial intervention, there won't be a trial of any kind?
Sir.
You understand that you're waiving your rights to trial, which are listed on page 2 of your sentencing recommendation?
Yes, sir.
You understand you're waiving all potential defenses that you may have?
Yes, sir.
And what is your plea?
Non-contest.
I'll accept your no contest plea is freely, voluntarily, knowingly given. Pretrial intervention agreement with the terms that I've previously stated. No new law violations, basic driver improvement, victim impact panel, $515 in court costs, $150 cost of prosecution. You'll provide proof of completion of all those items to your supervising probation officer. It's specifically listed here that there's no restitution and cost of supervision has been waived. I do have the agreement here for you, Mr. Berry. All right, Ms. Dudley's going to grab it for you. Thank you. All right, thank you, Mr. Moffet. Make sure you talk to probation. You've got 30 days to appeal the judgment and sentence of the court. Is that all?
That's all I have, Your Honor. Thank you.
All right, Mr. Keach. Morning, Mr. Keach.
Good morning, Your Honor.
Mr. Gulley.
Gulley, that's a Zoom appearance, 24 CF 84 and 24 CF 85.
You are in the meeting now.
I don't see him yet.
She emailed me earlier and said that
There she is.
on hold.
Sometimes it takes a second for it to come up. Ms. Gulley, is Cameron there with you?
I literally just had it.
Ms. Gulley, can you hear me?
Yes.
All right, is Cameron there with you?
Yes. Come closer. He's right here.
Okay, all right, thank you. All right, Mr. Keach, what are we doing with Mr. Gulley today?
Judge, I'm still ready for trial. I think the state was to announce which case they wanted to try first, but for my intents and purposes, we're ready to proceed.
Okay, Ms. Leone?
Your Honor, Ms. Gulley is here, and I would like to, I guess, confirm it with her the conversation that I had last week. She said that she cannot travel with her son, the defendant, in March due to some medical issues, but that she would be available in May. She's a material witness for the state, Your Honor, as far as the identification of the defendant is concerned.
So what are you asking?
Well, Your Honor, based on the unavailability of my witness, I would ask for a continuance, but it's my understanding that the defendant would not be available either. So if we can inquire into that with the defendant is online.
Well, Judge, Ms. Gulley's not even listed as a witness by the state in any of the 4 discovery exhibits they've provided, first. Second, the legal guardian of Mr. Gulley is his grandmother, Tracy Simmons. That's the address that's on his bond paperwork. That's the address listed on any other paperwork. So, I mean, if the state's asking for continuance for a witness that hasn't been listed,
Is she not listed as a witness on either case?
I'm very fine, Your Honor. It's taking a while to load the page. Well, this page, okay, it's getting there. Sorry. She's correct, Your Honor. We haven't listed it. However, it's obviously present, her name and her interactions with law enforcement in the report that we've shared in discovery. She is being interviewed by law enforcement, and
As you said, she's a material witness who Mr. Keach can't depose because she's not listed as a witness in your discovery.
well, Your Honor, I spoke with him last week. He could have mentioned it to me, and I would have added her. There was a discussion that she was a material witness, and I even filed it for the Williams rule motion.
You haven't filed a Williams motion.
I have filed a Williams rule motion, and Mr. Keach provided a response on objection in writing.
When was that filed?
last Monday, the same day she announced she intended to call Ms. Gulley as a witness to perfect the record.
But again, if the person's not listed as a witness, the defense can't depose him or her. So if you don't put her on the list, you're preventing the defense from doing so, right?
I apologize for the oversight, Your Honor.
This case is over a year old. And someone who's a listed, who talked to law enforcement, who's listed in the reports, and the state doesn't put her on a list, preventing the defense from doing their due diligence.
Your Honor, but it's also true that Mr. Keach has been in contact with Ms. Gulley, so she would have been available to him.
To speak with, but not to depose.
I will amend the discovery today, Your Honor.
Mr. Keach.
Judge, I'm ready, and I understand there's the trial concerns, but, when from a strategic standpoint and everything else, I mean, I would prefer to set the case. If we need to set it on the second week, let's do that, and let's proceed.
Which case does the state want to try first?
Your Honor, without Ms. Gulley, I cannot go forward. I need to have Ms. Gulley.
Well, I'm going to keep it set. We'll be back here on Friday for jury review, and y'all can talk about how this is going to work out in the meantime.
Would I ask the court please to inquire with the defendant if he's going to be available?
If he's not available, then there'll be potentially a capias for him. But otherwise, he's saying he's ready for trial. That means he has to be here on Friday. Y'all want to talk about which case first? Or
It makes
talk
no
about
diff-
that on Friday?
The state can pick the case if they want to pick. I thought that's why we were in part here today, is for them to announce which case we were proceeding on. And to perfect the record, there's been no offer made in the case either. It's been plead straight up to the court. So here we are.
Understandable.
It would be, Your Honor, 24 CF 85.
85. All right, we'll see you back on Friday. at 9 o'clock for jury review. I can't promise which week at this point until we go through the rest of the docket and find out who else is at trial or not. And frankly, we may need some extra coverage to make sure we have time to trial these cases, but we'll see how it turns out through the rest of the day. We'll talk about it at jury review.
And Your Honor, the defendant is expected to be in
He's
person.
expected to be here in person on Friday, March 7th, for purposes of jury review.
Thank you. That concludes my business. Maybe excuse me.
All right, thank you, Mr. Keach. All right, Mr. Hardy.
Good morning, Your Honor. My first case is Eric Copepper. Mr. Copepper is present and approaching. And Your Honor, we've got a plea to a lesser included offense of reckless driving.
All I have on Zoom. Mr. Culpepper, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. State your name and date of birth, please.
Eric Culpepper, 07-15-02.
All right. Mr. Culpepper, you're here in 24 CF 2397, currently charged with fleeing to elude a third-degree felony punishment up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that calls for a lesser included offense of misdemeanor reckless driving and 12 months of probation with basic driver improvement course, as well as some fees and costs. Is that what you want to do today?
Yes, sir.
Is that the state's?
It is, Your Honor.
That's the state's agreement. All right, Mr. Culpepper, have you gone over this plea and sentencing agreement between you and the state attorney's office with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
If you had any questions, did Mr. Hardy answer those for you?
Yes, sir.
All right, and are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Have you been forced, pressured, or threatened in any way to enter this plea?
No, sir.
Have you been promised anything other than the terms of the agreement in order to get you to plea?
No, sir.
All right. You understand by entering a plea of no contest, you'd be giving up your right to a trial.
Yes, sir.
You'd be giving up a right to all the trial rights that are listed here on the first page that you went through.
Yes, sir.
And you understand that you're waiving all potential defenses that you may have to this charge.
Yes, sir.
And what is your plea to the lesser included offense of misdemeanor reckless driving?
No contest.
Except your no contest plea is freely, voluntarily, knowingly given based on state's agreement. 12 months probation, cost of supervision is being waived for what reason?
Your Honor, he's out of work currently.
Any objection from the probation? All right, state. Based on no objection from probation or the state, cost of supervision will be waived. $275 court costs, basic driver improvement course. Make sure you complete those during your probation, sir. Otherwise, you could be violated. Step over and talk to probate. This is DOC probation still?
Yes, Your Honor.
All right. Step over, talk to probation. You have 30 days to appeal the judgment and sentence.
Other cases, Vince Ramirez, and Mr. Ramirez is present and approaching. Your Honor,
I'm sorry, it was a withhold, I believe.
Yes. Your Honor, Mr. Ramirez, we were here to plea today. Due to circumstances outside our control, the state needs to look at some things before we finalize a plea agreement on Mr. Ramirez, so I'm going to ask to continue this case.
Case is a year old. What has to be looked into?
There was some rehab that we did. Your Honor, can we approach?
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now
Mr.
7
Ramirez, we're
days a
gonna put
week.
you on your next
Normal
pretrial date. It'll be the
hours that
last
you've
one,
been expecting.
potentially, if it isn't worked out ahead of time, but that will be April 28th at 9 a.m. See you back on that date.
Thank you, Your Honor. That's all I have.
Thank you. Mr. Flowers?
Oh, come on now.
Read my mind. I was going to call you. You were standing up.
Judge Reagan Phillips. Judge, we've been through his VOP paperwork. He was unable to sign it. He was in the back, but we're
Is this
prepared.
under Mr. Shaw?
It's under Mr. Shaw's name, yes, sir. Just sign it right there, okay? Judge, if I can approach. Nobody else is.
Thank you, sir.
Judge, Mr. Phillips at this time would admit the violation consistent with the agreement that you have. Mr. Phillips and I had been through this agreement. He had not signed it, but Judge, the terms are as follows, that he would be adjudicated and placed on 1 year community control followed by 2 years drug offender probation with statutorily mandated costs. Is that right? Yes, sir. And that's what we had discussed? Yes, sir. Yes, sir. Judge, that's the totality of the agreement as I understand it with the state.
1 year community control followed by 2 years drug offender probation.
Yes, sir.
Says comply with Emerald Coast Life Center. Is
That's
that
correct.
Done outside of the jail?
In fact, he's already been approved for that, but yeah, that's part of it.
That's
He's already,
two classes a week in Crestview.
yeah, he's already doing that. The mental health evaluation that the state brought to my attention, he's doing that even as we speak. So we have no problem, Your Honor, with you announcing that and that he's doing it and that was contemplated and he's already begun.
Yes, that's
Yeah.
with the Crane Center in Destiny.
Yeah.
One thing is, I think he had the possession of a controlled substance. Did he not have probation on the paraphernalia charge? I just want, it was time served before, so it
Yes,
was
sir.
not probation. Just
That's
wanna make
correct.
sure
Yes, sir.
I'm saying it cleanly.
Understand.
All right, Mr. Phillips, can you raise your right hand? Do you swear or affirm that the state, any statements you're about to give is the truth, the whole truth, and nothing but the truth?
I do, yes,
All
sir.
right. State your name and date of birth. So I got a little ahead of myself in my.
Reagan Eli Phillips, September 7th, 1978.
Okay, and Mr. Phillips, you're here for a violation of probation in 23 CF 729. I've been given a plea agreement that calls for you to admit your violation of probation and be sentenced to 1 year of community control followed by 2 years drug offender probation, $100 cost of prosecution, comply with the Emerald Coast Life Center mental health evaluation, any recommended treatment, and complete all terms and conditions of your original probation. Is that what you want to do today?
Yes, Your Honor.
Is that the state's agreement?
Yes, Your Honor.
All right, thank you. All right, have you gone over this plea agreement with Mr. Flowers?
Yes, Your Honor.
And did you understand it?
Yes, Your
Did
Honor.
he answer any questions if you had any?
Yes, Your Honor.
And are you satisfied with his advice and representation?
Yes, Your Honor.
Are
very
you
much
under
so.
the influence of any alcohol, drugs, or controlled substances? Are you under the influence of any alcohol, drugs, or controlled substances?
Oh, no, sir. No, sir.
Am I speaking too fast? Is that-
No, I couldn't hear you.
Okay. Just make sure it's working. All right. Do you suffer from any mental health issues or concerns?
Sir, I'm diagnosed bipolar schizoaffective.
Okay. Is
So-
that preventing you from understanding what we're doing here with this agreement?
No, sir, not at all, not at all.
I
No,
just
sir.
have to ask.
No, sir.
Do you need any more time to go over the agreement?
No, sir, not at all.
Okay. Has anyone forced, pressured, or threatened you to take this agreement?
Oh, no, sir.
Has anyone promised you anything other than the terms of this agreement to get you to plea to admitting your violation of probation?
Definitely not, Your Honor.
All right. Do you understand that by entering an admission that there won't be a hearing where the state would have to prove you violated your probation?
Yes, sir.
Okay. And you understand that you're waiving any potential defenses that you may have to your VOP?
Yes, Your Honor.
All right. And what is your plea? Are you admitting or denying your violation of probation?
I'm admitting.
All right. I'm going to accept your admission. to the violation of probation, adjudicate you guilty. You understand that makes you a convicted felon, if you weren't so already?
Yes, Your Honor.
Okay. 1 year of community control followed by 2 years of drug offender probation, $100 cost of prosecution, comply with the Emerald Coast Life Center, which you're already doing, mental health evaluation, any recommended treatment, complete all original terms and conditions of your probation. Mr. Phillips, if you have no other questions, I'm going to have you be fingerprinted. You have to speak with probation, and you have 30 days to appeal the judgment and sentence of the court.
Yes, Your Honor.
It's a guideline sentence from what I've seen.
It is, Your Honor.
Thank you, sir.
And Your Honor, we're revoking the old probation?
Yes.
Thank you.
Judge, the next matter I have before you, it's under my name, Terell Herbert. Ms. Herbert is present, Your Honor. We had set this for plea or continue, and I think the reason was we were hopeful that we would have an agreement. We do not, through the fault of no one, perhaps mine, but we don't have an agreement. We anticipate there will be, in fact, strongly believe there will be. It's a PTI recall, as is reflected in the docket. Your Honor, we're merely asking that we continue this to give us an opportunity to do so.
Ms. Leone?
I don't have an objection. It was not set for trial.
It was not, that's correct.
All right, so you guys are still working on it?
Yes, sir.
How long has she been back on the PTI recall?
That I don't know.
That's the problem, is the docket doesn't tell me that, it just tells me the original case
Yeah,
date, which is in 2023.
I'll confess, I don't know the answer to that.
I'm sorry, Mr. Flowers. In the memo that I have from since December 19th.
So it's not terribly old.
That sounds correct. Yes, sir.
All
Thank
right,
you.
well, let's see if we can get that resolved the next time around. It's going to
Agreed.
be April 28th at 9 o'clock will be your next pretrial conference, ma'am. Make sure you stay in touch with Mr. Flowers and be back on that date.
Thank you.
All right.
Judge, the final matter I have is Mr. Roller. It's on my page 7, under Tim Shaw's name, Jonathan Roller. Mr. Roller is with us today. Judge, this was not contemplated as a trial as well. He had co-defendant that I think disposed of his case with Attorney Stephen Webster the last time we were here, if I'm not mistaken. And that makes that individual a potential witness. However, we believe that this is set for April 28th. It'll be disposed of prior to that date.
Prior to that date?
I believe so, Judge.
Okay.
No objection.
No objection. All right. Well, I'm familiar with the circumstances. It'll be April 28th, but we've got to get this one resolved. Certainly by that, you said that's going to happen, but.
Yes,
make
thank
sure
you,
that
Judge. That's all I have.
All right. April 28th, sir.
Thank you, sir.
All right. Ms. Merrifield, I think you're recovering from Mr. Nopes. Come on up. Yes.
Nopes is picking a jury in the South End. The first case he has is Andrew Barnell. It's 24 CF 1308 and 24 CF 496. I believe this is ASA Leone's case, and he is requesting a continuance. I don't believe there's an objection.
No objection.
I don't want to ask you, Ms. Merrifield, but Ms. Leone, any reason why this case is still around? I know there's a new case, but the first one is from June of 23.
We were in negotiations, Your Honor, and I believe we might have had a plea today, maybe if Mr. Nopes had been available. I believe that it will be resolved prior to next pretrial.
Do you want to try to bring it back earlier than that, or just have Mr. Nopes plan that?
I would leave that up to the court, Your Honor.
Without him here, I don't want to schedule anything for him.
Absolutely. And Judge, I would just request then to set it for the next pretrial, and then if Mr. Nopes perhaps is able to bring it in early, I know he certainly will.
That'll be fine, Your Honor.
All right, April 28th at 9 o'clock, Mr. Barnhill. But obviously, if you talk to Mr. Nopes and y'all want to bring it in earlier, I'll certainly accept a resolution earlier if there is one.
Thank you, Judge.
All right, thank you.
And then we have Brian Boyd, 24 CF 2137.
Brian Boyd.
I'm uncertain if Mr. Nopes has a waiver on file for Mr. Boyd. He is also requesting a continuance, and I believe ASA Glisson is covering this case.
This is not an old case. So we'll go April 28th at 9 o'clock.
Thank you,
for
Judge.
his next pretrial.
Then the last case is J.C. Rycroft, and that's 24 CF 1676. Mr. Rycroft is present and approaching. And Judge, he's also asked to continue this to the next pretrial conference. I believe ASA Glisson is covering, and I don't anticipate an objection.
No subpoenas were sent out. I think there was just talking to the alleged victim. All right, Mr. Rycroft, you've been here a lot. We'll see you one more time at least. April 28th, 9 o'clock.
Yes, sir.
This one's just been on the verge for a long time. So it seems like
Thank
it's
you,
been
Judge.
every court date we've had.
I believe that's all I have now.
All right, thank you, Ms.
Appreciate it.
Scaffield. Mr. Powell or Ms. Gooden, I'm not sure who was here first, if you want to arm wrestle for it, or? All right, come on up.
Bo Powell for the record. I have Justin Busby on the docket, 23 CF 2415. It might be on your docket.
I've got it. It's number 1 on the docket.
No problem.
Because of your co-counsel. Who has Busby?
This is Ms. Bosow's case.
I'm just making sure I know who's got the case. What are we doing with Mr. Busby?
Judge, we have depositions scheduled in Mississippi on April 3rd and depositions scheduled in Okaloosa on April 9th. There's 2 kind of pending cases, one in Mississippi, one here, but a lot of the witnesses for here are in Mississippi.
There's no objection to a continuance, Your Honor. We did receive a notice of deposition. They are formally set.
Say again, I'm sorry.
Your Honor, there's no objection to continuance. We did receive the notice of deposition. They are formally set and all ready to proceed.
I think there was a written motion to continue previous. I just wanted to find out kind of where we're at with it. Sounds like
Sure.
the depositions have been set.
And Judge, we have had them set a couple of times. There's just been a lot of logistic issues. There's 2 other attorneys, and then when we had them set up in Mississippi District Attorney's Office, and they canceled those due to, they had some maintenance AC issues.
The air conditioning, right? I think we
Yeah.
talked about that last time.
Yeah.
All right, April 28th at 9 o'clock, Mr. Powell, but let's get those depositions done. Let's hope everybody shows up and we can resolve the case one way or the other next cycle.
Yes, sir. We're working towards resolution one way or the other.
Anything else, Mr. Powell?
No, sir, I don't.
Thank
Thank you. Have a good day.
Gooden? There it is.
Morning, Your Honor. Cheryl Gooden for Wesley Bertrand, 23 CF 2071. May the state and I approach?
Yes.
But now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients as
on Friday for a possible resolution. Obviously, if something comes up in the meantime, certainly reach out. But put it on the record. If y'all do negotiate a plea on this case, I'm willing to accept it after today's cutoff, depending on what it is. But I still have to approve that at this point. All right, we'll see you on Friday.
Thank you, Your Honor. No, Your Honor, thank you.
You have Ms. Flowers?
I have just 3 that I'm ready to go with, if that's all right with
Flowers is typically goes before the public defense. Do you want him to go? All right, Mr. Gibbs.
All right, first, if I may call Mr. Demarcus Abrams. Yes, sir. Your Honor, we've reached an agreement in Mr. Abrams' case. If I may approach.
Mr. Abrams, if you could raise your right hand, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please?
Demarcus Abrams, 08-1203.
All right, Mr. Abrams, you're here in 24 CF 204, charged with false information to a pawnbroker, which is a second-degree felony, punishable up to 15 years in state prison. And 24 CF 520 with 1 count of uttering forged bills, third-degree felony, punishable up to 5 years in state prison. And petty theft, $100 to $750, which is a first-degree misdemeanor, punishable by up to a year in county jail. Do you understand all that? Do you understand all that? Yes, sir. Okay. I need to hear you out loud. All right. I've been handing a plea and sentencing agreement for you to plead no contest as charged to those 3 cases for 2 years of probation, $100 cost of prosecution, waive costs of supervision, $415 court costs in each case, $100 PD fee for each case plus a $50 application fee. Reserve jurisdiction on restitution for 90 days. Anti-theft class, no contact with the victim. And may auto-terminate at 1 year if you've completed everything that you're supposed to do. Is that what you're wanting to do today, Mr. Abrams?
Yes, sir.
Have you gone over this plea agreement with your lawyer?
Yes, sir.
Has he answered all of your questions?
Sir.
Did you have enough time to speak with him? Are you satisfied with his advice? All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
Sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the negotiated agreement to get you to plea?
No, sir.
And do you understand that if you enter a plea, there won't be a trial on any of these counts? And do you understand that you'll be giving up your trial rights, which are all listed on page 2 of the agreement that you signed? Is this the state's agreement?
It is, Your
And
Honor.
it's a guideline sentence, correct?
It is with me.
All right. Mr. Abrams, what is your plea to all 3 counts?
No contest.
All right. I'll accept your no contest plea and as charged for all 3 counts. For the 24 CF 520, which is a misdemeanor theft, it's going to be time served. For the 2 felony counts, 2 years probation, waive cost of supervision due to the fact that you've been declared indigent, $100 cost of prosecution in each case, $415 court costs each case, $100 PD fee in each case plus $50 application fee, order restitution, reserve as to the amount for 90 days, anti-theft class, no contact with the victim, who is, do we have a name?
The alleged victim in the first case, Judge, is
Entered
going
a
to be
plea, it's no
Walmart.
longer alleged.
Correct. The victim listed in the second case, Judge, let me pull up that information.
It's Brianna Lee Zahara. It's spelled Brianna Breanna. Last name Zahara.
Okay. So, Mr. Abrams, you know you can't have any contact with this person. And if you do, you could be violating your probation and could serve up to 20 years in prison.
Yes, sir.
Okay, make sure you do everything you're supposed to. I didn't say this yet, but I said it the first time. May auto-terminate at 1 year, assuming that you've got everything done that you're supposed to get done, Mr. Abrams. Say again. It's a withhold. Probation is concurrent between the 2 charges, the felonies. All right, step over and talk to probation. You have 30 days to appeal the judgment and sentence.
Your Honor, you made reference to the early term. Is it the court's position, if he has done everything, that after a year we can turn him loose, or do you want us to come back to the court?
I think the auto terminate says that they agree to do it automatically.
Okay. They like the term shall. Can I put that in there?
I would certainly request that, Your Honor.
All right. Shall auto terminate after 1 year if everything is completed.
Thank you, Your Honor. Thank you, Mr. Berry. Your Honor, the next case that I have is Mr. William Flanigan. Your Honor, Mr. Flanigan is present approaching. This is 23 CF 2730. As the court may recall, we had set Mr. Flanigan for this date to make sure that the court had an opportunity to review and read the evaluation reports from Doctors McDonald and Zeman. If we need to set it for a competency hearing, we're certainly prepared to do that.
So my understanding is, it just took me a while to track back into it. Back in April, there was a evaluation by Dr. Zeman showing not competent, but also Dr. McDonald did an evaluation report from September. I don't think I see the motion. In order, doing the second appointment was done, but I don't see where a motion was ever filed for it.
You have it set for a hearing, Your Honor?
I mean, we can set it for a hearing if the state's asking for
And,
that.
and we can file a motion to that effect, Judge.
I don't, if the court and defense are requesting a hearing,
Well,
I haven't reviewed the report, so I'm not.
The only thing I can do is if the state's willing to stipulate based on those two. Otherwise, we'll set it for a hearing where, Ms. Glisson, you have a chance to review them, and then I'll make a determination once you decide if you want to go forward on the reports, or are we going to have to bring the doctors in, which I'm fine with either. It's just, since the file's new to you, I want to make sure that you have a chance to do that. March 27th.
We do March 27th, and I think that's a
All right.
miscellaneous day. And we'll make sure to file a motion to set it for competency status or whatever
March
motions we need.
27th at 9 o'clock for the hearing. Obviously, if y'all are going to stipulate, if you could just give me a heads up on that, so that I know if we're actually going to have a hearing where the doctors are going to testify.
Thank you.
Just for timing purposes, we want to make sure we have enough time.
Thank you, Judge.
And just, I guess I'll put it out there, if we ever need doctors to appear by Zoom for purposes of these types of hearings, as long as there's no objection, I'm certainly willing to do that as well.
Very well, thank you.
All right, we'll see you back on March 27th, Mr. Flanigan. Stay in touch with Mr. Gibbs.
Okay, thank you, Your Honor.
We'll set it for another hearing.
What now?
Give my office a call so we can talk.
Yes, sir.
Yeah, all right, you're good to go. You're good to go. Stay in touch. Your Honor, the next case that I have is Mr. Jart Franklin. Your Honor, Mr. Franklin is present and approaching. We have reached an agreement, if I may approach.
All right, Mr. Franklin, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
All right. State your name and date of birth, please.
Jart Franklin, 1975.
Mr. Franklin, you're here in 24 CF 1153, currently charged with aggravated battery, punished by up to 15 years in state prison as a second-degree felony. Do you understand that?
I do.
All right. I've been handed a plea and sentencing agreement that would have you plead no contest to a lesser included offense of misdemeanor battery. You'd be adjudicated guilty, time served, $50 cost of prosecution, $622 in court costs, $100 PD fee within the 180 days or sent to judgment. Is that what you want to do today?
Sir.
Is that the state's agreement?
It is, Your Honor, just for the court costs. Is that the misdemeanor court costs, Madam
It's
Clerk?
misdemeanor, but is it domestic?
It'd be misdemeanor battery. My understanding was always it's about 622, but if that's incorrect, I am open to
I just want to
correction.
make sure I don't.
622. I think that there's the normal 270 court cost, but was it 201 and 151 or something like that? I think it's been that since I was a baby prosecutor 20 years ago. All right, Mr. Franklin, have you gone over the plea and sentencing agreement with Mr. Gibbs?
Yes, sir, I have.
Did you understand it?
Totally. Yes,
Did
sir.
you sign it?
I think I did, yes.
Okay, I'm looking at a signature that appears to be yours. At least it's listed in the defendant section. Is that yours?
Yeah, I might have put it in the wrong spot. Yes, sir.
Okay. Are you satisfied with the advice and representation of Mr. Gibbs?
Very much so.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to take this plea deal? Say again.
Not in any way.
Okay. Did anyone promise you anything other than the terms of the plea agreement in order to get you to plea? All right. Do you understand there won't be a trial of any kind?
I do.
You understand that you're giving up all of your trial rights, which are listed on page 2 of your agreement? You understand that you're waiving all potential defenses that you may have? All right. And what is your plea to the lesser included offense of misdemeanor battery?
No contest.
All right. I'll accept your no contest plea to the lesser included offense of misdemeanor battery per the state's agreement. Adjudication of guilt, time served, $50 cost of prosecution, $622 in court costs, $100 PD fee. You're to pay that within 180 days, otherwise it'll be sent to judgment. You have 30 days to appeal the judgment and sentence of the court. I'll need you to be fingerprinted before you leave. All right, thank you, Mr.
Thank you, Your Honor. And I believe that completes my business, if I may be excused.
Thank you. All right, Ms. Flowers, if y'all don't mind, we'll take about a 5-minute recess.
All right, please.
Is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
this is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Where I Prech Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Nine o'clock, and that's for a resolution.
I'll come see you in
Thank you so much,
yeah.
honey.
You're welcome, sweetheart. Okay. Let's see.
27th at 9.
Yes, thank you. Oh, yes, if that's okay. Yeah. Okay. Germaine Parker. We have reached an agreement with the state, and we have gone over this agreement. Mr. Parker just needs to sign physically. Okay, that's not working. Sorry, there you go. The only thing that's different. May I approach?
Yes. All right, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. State your name and date of birth, please.
Parker, December 3rd, 1982.
All right, Mr. Parker, you're here in 24 CF 2270. You're charged with kidnap or false imprisonment, which is a third-degree felony, punished up to 5 years in state prison, and obstructing justice, second-degree felony, 15 years maximum sentence. Do you understand those charges?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that calls for you to plead no contest to both counts and receive 2 years of community control. Is that what you're wanting to do today? Is that the state's agreement?
This is its agreement.
As the state taught to the victim in the case?
We have reached that agreement because of victims' wishes.
Victim's wishes were for him to get community control for that?
Yes, Your Honor.
Okay, and I'm looking at a score sheet where he would score 40.8 months. So it's an agreed-upon downward departure based on the agreement?
That's correct, Your Honor.
All right, Mr. Parker, have you gone over this plea and sentencing agreement?
Yes, sir.
Did you understand it?
Yes, sir, I did.
Did you sign it?
Yes, sir, I did.
Did Ms. Flowers answer any questions if you had any?
So she did.
Are you satisfied with her advice and representation?
Yes, sir, I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to get you to take this plea? Has anyone promised you anything other than the negotiated plea in order to get you to plea?
No, sir.
You understand if I accept your plea, there won't be a trial of any kind?
Yes, sir.
And you understand that you're giving up all of your trial rights, which are listed on page 2 of your agreement?
Yes, sir, I do.
And you understand that you're waiving any potential defenses that you may have? Is this domestic?
Yes, Your Honor.
Are there children involved?
Yes.
Have y'all talked about that as far as child exchanges and things like that? Is there an injunction or a family law case?
No, they're married, and it's the intention.
But there's a no contact unless the victim provides a sworn affidavit to probation requesting contact.
I asked for that provision, Your Honor, because we're not sure as to the legal shared custody of the children. They may be in the process of establishing that in another case, but I'm not aware.
Mr. Parker, are you aware if there's
No, sir, there is not. Absolutely not.
There's not a family law case?
No, sir.
Are y'all married?
Yes, sir.
It is our understanding that the alleged victim will make that statement as soon as she's able to, probation and writing.
That she wants contact?
Correct.
Yes, I can't make any contingencies here, Mr. Parker, so
Yes,
if
sir,
she
I
doesn't
understand.
do that, and there's nothing else establishing any sort of rights to time sharing, if you can't have contact, that makes co-parenting very difficult.
No, sir, there won't be no issue.
My concern with that, Mr. Parker, is which is a pretrial detention order that was signed by the court in October. You're supposed to have no contact with her previous, so I'm not sure how you would really know that.
I've spoken to the victim, Your Honor.
Okay. Because the state hasn't about this particular issue, it sounds like. So I just want to make sure that everyone understands when conditions are put into place, they can't just be changed on contingencies. All right, any other questions, Mr. Parker? What is your plea as to the false imprisonment and obstruction of justice?
No contest.
No contest.
I'll accept your no contest plea as to both counts, adjudication of guilt, 2 years community control, concurrent. You're to complete the Batterers Intervention Program, which is a 26-week course. The Emerald Coast Life Center or similar program, which would include substance abuse counseling. That's concurrent between each charge. $150 cost of defense, waive cost of supervision, no contact with the victim, your wife, unless she provides a sworn affidavit to probation requesting contact. What were court costs? $515 in court costs. And this is the state's agreement to downward depart as well.
Yes, Your Honor.
All right, sir, you've got 30 days to appeal the judgment and sentence of the court. You need to be fingerprinted and speak with probation about your community control.
And Your Honor, we request supervision fees be waived.
I think I said that, but if I didn't, waive supervision fees since he's indigent.
And you referenced the Batterers Intervention Program and a substance abuse evaluation and ECL.
Well, I'm doing it based on what the agreement says. And what it says is BIP, ECLC, or similar substance abuse counseling program. Again, my
Batterers
concern would be when it
Intervention.
says similar, what does similar mean? Because
From probation standpoint, if you say batterer's intervention, we have to send him to a licensed provider.
The intention of the plea, I'm sorry for the wording, is batterer's intervention and CCLC, or like ECLC or similar, but batterer's intervention.
Batterer's intervention is a definite.
Is a definite.
Standalone.
Correct.
And then the ECLC or similar is a different condition.
ECLC or the substance abuse, is that where you're
Correct.
trying to go with that?
Yes.
A substance abuse counseling program.
Or ECLC.
Or ECLC.
Thank you. There you go. Appreciate it, Judge.
First. Maya Turner is present and approaching in 24 CF 2774. I have her case in misdemeanor as well, a driving case that Judge Ward's been working with her. I was unable to get with the state about that situation, so I'm just asking to continue to further work that out because she's been working really hard to get her license.
All right, Ms. Turner will be April 28th at 9 o'clock for your next court date. Make sure you make that court date and your misdemeanor court dates, because they could be on different dates.
Yes, sir.
All right.
Ashley Woody is present and approaching before the court in 24 CF 2724. It's my understanding there's no objection to continue this case. There are some things that came to light after our last court date that.
Okay, and this is
Right,
just from
continuance.
November. So Ms. Woody, it's going to be April 28th at 9 o'clock. I'll see you back on that date. Stay in touch with your lawyer.
And Calvin Tipton is my last case on the docket for this morning. And the VOP is 16 CF 1262, and the other case that's pending before the court is 22 CF 894. We're asking for a continuance one last time in this case to get everything coordinated for the state, with the state for trial.
We just have the outstanding motions that we need to set a date today if the court would like, so that we have them set.
What is that, Williams rule?
Child hearsay.
We'll maybe do April 10th, which is a arraignment at 1:30, and just put this at 2 o'clock. Just the March 27th date in the afternoon's getting pretty full, and so if it's going to be potentially lengthy, I don't want to keep y'all here till 6 or 7 o'clock again.
Judge.
All right, let's do April 10th at 2 o'clock.
Have a good day.
And I'll get that Taylor plea written up. Thank you.
All right, thank you. Sure.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5000. 5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers.
All right, Mr. Williams.
Judge, I'm going to call Ronald Norris if he's available. Judge, this is Ronald Norris. As the court's aware, I've been trying to get the case in for a trial. Spoken with the state attorney. At this point, it looks like, I don't know what percentage, but a giant percentage of the witnesses are not going to be available for the trial weeks this time. What I'm going to ask is that we get a date certain in May, so that we can all just tell them, look, you're just going to have to be there, and we can get those subpoenas out this week.
On both sides?
Some of the I've got some police officer witnesses that I would like to call, the folks that were out there the first time and the second time. That's primarily who I'm going to be seeking.
The state has already gotten subpoenas out. We've received phone calls from 2 officers that they are unavailable the second trial week due to Okaloosa County spring break and
Anything that you want to say? I mean, the other issue is I'm still waiting on briefs, not briefs, at least one, if not two. Briefs. There's a response brief and a reply brief I'm still waiting for, which I'm starting to regret having done because that was January 15th, I believe. And we're 6 or 7 weeks from that, and I still don't have those to rule on the stand your ground motion.
I believe that my due date is midnight tonight, Judge, and I anticipate that the court will have it. I was not able to do it earlier. I know the court asked if we could try to expedite those and get those in earlier, but I simply was not able to do that. I also, depending on the court's ruling, that may resolve the case, or I may need to discuss with my client whether to do a writ of prohibition or leave it on the docket for trial. And we did ask for the court to do a written ruling on it so that
I'm going to. I'm just waiting on the written briefs. So I know we had a delay because of the snowstorm and you couldn't get the transcript any faster because of that, and that's really put a delay on things. But I'd like to at least get that part of it done as soon as possible.
Yes, sir.
This case is over 3.5 years old.
Yes, sir.
And Your Honor, the state may not even have a reply brief, and the state would file its motion in limine as well, along with its reply brief by Friday.
Motion in limine
regarding this case. That way we can get any motion in limine hearing on and make sure that we are ready for the May trial cycle.
Norris, anything from you?
Pretty much at the mercy of the court.
Well, I understand, but I'm at the mercy of the parties. So all I can do I think a lot of people are mistaken about how some of these things work. I mean, both sides are asking for more time because of witness availability issues. And if I force everybody to trial, that could be detrimental to one side or the other. I want to make sure that we're having this trial once. If we need to, I don't know. I haven't read the brief from the defense yet. I've got to make a ruling on the stand your ground. I'm not trying to, if anything I'm saying is coming off as I might rule one way or the other, I apologize for that. I don't know what's going to happen until I get a chance to read it all, do my own continued research, and make a written order as to whether or not I'm granting your motion, Mr. Norris. But unfortunately, I feel like this case kind of spun its wheels for quite some time until recently. And so I don't want to continue it. I've based a lot of how we're going to handle this cycle around what we're going to do with your case. We've talked about which week it would be, whether or not I'm going to need coverage for other cases so that I can handle your case, because obviously I'm not going to have someone else cover a case of this magnitude, especially when I've been through the stand your ground. I think that's one of the reasons why we're here at this late date. So I don't like the idea of continuing it, but I also don't want to. I'm really trying to not say anything that makes it sound like I've made a decision on stand your ground, because I haven't. But if I were to rule against you and your counsel and you want to take a writ up, getting that done quickly and not in a moment's notice is probably a better thing for you as well. So I hate to do it, Mr. Norris, but that's why I'm asking if there's any particular objection you want to give, that we talk about it. Otherwise, I'll continue it. We'll decide which of those dates we're going to do, and that'll be the end of it. Short of some medical emergency or something like that, where someone who's vital to the trial can't be there, I don't intend to continue it again.
The state intends to get their subpoenas out tomorrow, Judge.
The defense will do the same. I'm just asking for at least a week, which week we want to set for.
I think it's probably going to take us an entire week to get through the trial.
Yes,
That's
sir.
what I would expect. I mean, it took us a day and a half just to do the stand your ground hearing.
I would agree. I just want to know which one to send my subpoenas for.
I think the first week would be preferable.
Okay.
We may approach, Your Honor.
Sure.
In the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
All right, Mr. Norris, I'm going to set you for your next pre-trial. It's going to be April 30th. Trial date will be May 12th. It'll be that week. Everyone's going to send out their subpoenas now for the May 12th trial week. If there's any issues that arise between now and pre-trial, which will be April 30th at 9 o'clock, I need to know about them as soon as possible.
Sir. Yes, sir.
Because this
kind of case is going to involve a lot of potential jurors. We got to make sure we've got a good pool in as far as numbers. So I really want to make sure that everyone knows this is the last time we're moving this case. It's going to be resolved at the next cycle.
Yes, sir.
All right, thank you, Mr. Norris.
And Your Honor, that concludes my business with the court. May I be excused?
Yes.
Thank you.
One last thing, Mr. Williams, when you do file that brief, send a courtesy copy to my office. Otherwise, I may not see it right away. And then
Yes,
again,
sir.
Ms. Sandler, if you're not going to respond, or if you do respond, send me a quick courtesy copy, just so I know it's there.
Sir.
Otherwise, I don't know. When things get filed, I don't get an alert on that unless you send it directly to me.
For my purposes, Judge, I'm going to send it to both of you by email. My secretary may have to do the actual filing. Myself, I don't know that I'm savvy enough to figure out how to make that.
Okay, no problem. As long as I get it and I know it's the final product.
Yes, sir.
All right, thank you. Taylor?
Ms. Taylor, yes, in 24 CF 2230, we have reached an agreement with the state, if I may approach.
Thank you. All right, Ms. Taylor, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You're here in 24 CF 2230. I'm sorry. Can you state your name and date of birth, please?
Megan Taylor, November 11th, 1987.
All right. And you're charged with possession of a controlled substance, third-degree felony, punishable up to 5 years in state prison. I've just been handed a plea and sentencing agreement that calls for you to plead no contest to a lesser included of possession of drug paraphernalia, which is a first-degree misdemeanor. Adjudication of guilt, credit for time served, $270 in court costs, $100 cost of defense. And then you'll pay those within 90 days, or then I'll go to collections. Is that what you want to do today? Is that the state's agreement?
Yes, Your Honor.
All right. Ms. Taylor, did you go over this plea and sentencing agreement with Ms. Flowers? Did she answer all your questions? Are you satisfied with her advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues or concerns? Did anyone force you to take this plea agreement? Did anyone promise you anything other than the terms of the agreement to plea? Do you understand there won't be a trial of any kind if you enter the plea? And do you understand you're giving up all your trial rights, which are on page 2 of your agreement? And do you understand you're waiving all potential defenses that you may have had?
Yes, sir.
All right. And what is your plea to the lesser included possession of paraphernalia? All right, I'll accept your no contest plea as freely, voluntarily, knowingly given to the misdemeanor paraphernalia. Adjudication of guilt, credit for time served, $270 in court costs, $100 cost of defense. Pay those monies within 90 days. Otherwise, it'll go to collections. All right. And you have 30 days to appeal the judgment and sentence. Thank you.
And if I may briefly recall Mr. Parker, Germaine Parker, to address the contact situation with probation.
Your Honor, we asked Mr. Parker where he was going to live. He provided us with the victim's address. I told him, we can't just let you go over there. She has to come in and sign an affidavit. Once we get the affidavit signed, we would have to get an order to you saying we're good with that. I just didn't want him to break his agreement right from the jump. So I stopped him, and here we are.
Yeah.
And I was not aware of that it would take the steps like that, so you're just gonna have to stay in a hotel until that's done. Unless the state's willing to.
I'm sorry.
I mean, it's just, his plan was to go home, but they're gonna have to get all the steps done, so. State's not willing to amend that.
Again,
Absolutely not,
how
because-
is this all being discussed when there's a no contact provision?
The victim indicated that she did not wish to have reside, at least, at the very least, reside with him. She didn't want to.
All right, so you can't reside there, Mr. Parker, until it's been approved and probation sends me something to amend it, because they've got a sworn affidavit from her as to what she wants.
and having any sort of contact with her whatsoever, directly or indirectly, which means through a third party, tell her that I said this to someone else, that's going to be a violation of your probation. And then you're looking at coming back and being dealing with a VOP, where you could be sentenced up to the maximum if you found to have violated your probation by doing exactly what I'm talking about right now. So reaching out to her to try to talk to her about living there is going to be a violation of your probation. Do you understand that? So you can't live there. Any questions? All right.
We will reach out to the victim to let her know that she can provide that affidavit to us.
Okay.
And then we'll know what to do.
And by affidavit, that means it's got to be notarized. If she comes into the office, great. Otherwise, she has to say this uncoerced before it can be changed. This is why I kind of asked about all these things on the front side of it, so we wouldn't be dealing with these things, and this is exactly what I thought was going to happen. I'm not trying to say, look at me, I figured it out, but this is what happens. So these are the things we have to look out for when we're making plea agreements. If there's children involved in a domestic situation, this is often what happens. If there's no family law case, there's no injunction in place, something's got to resolve these issues. Otherwise, they're just kind of out there without any guidance or proper restriction that can be met. All right.
Thank you.
Yeah, I've got some more.
All right, Mr. Williams, are you back up?
I can be. Yes, sir. All right. Thomas Heder-Shide.
Would that be under your caseload, or is that?
It would be, Judge.
Okay, I just want to make sure I'm finding the right spot.
Yeah, I don't get to the other caseload until I've got a couple of people that are in jail. Judge, Mr. Heder-Shide was here earlier, signed the plea agreement. Let me just move on to the next one, and we'll bring him back up. William Jackson. Judge, we've got a different prosecutor in the case. I spoke with her last week. I've also spoken with Mr. Jackson and with my expert witness. This is one where Dr. Zeman would be testifying. Dr. Zeman's not going to be available either week this trial cycle. And I believe the state had indicated that they wanted a convenient continuance in our conversation. This is the...
Can you speak with Mr. Williams?
Ms. Leone. I thought Ms. Leone had it. When we talked Friday.
This is Ms. Turner's case. We don't object to a continuance.
Okay. Are you going to be taking over Ms. Turner's stuff for now, or?
Unknown.
Unknown? Okay.
We'll let you know, Mr. Williams.
All right. I'll work with whoever.
Very old case, Mr. Williams. Due to the circumstances, it's going to be, let's see, April 28th at 1 o'clock. Mr. Jackson, be back at that time. I mean, obviously, if this is going to be a trial, we expect an expert to be testifying potentially. Let's make sure we got that figured out. Everything's disclosed. Depositions have been taken.
I actually see where defense counsel today added a defense witness, so we'll try to get the deposition set and completed.
I'm not pulling fingers. I just want to make sure that we don't come back next time and we're still trying to figure it out. So we'll come back April 28th at 1 o'clock, Mr. Jackson. We'll see you then.
Thank you, Judge.
Especially if there's any sort of reciprocal expert. Not, I guess he's the reciprocal side. You're if there's a state expert that needs to come into it, we're just being as quick as we can on these things. I'm not sure why a September 23 case is still kicking around, but here we are.
William Cohen. Judge, this is a negotiated plea, if I can.
Going with a K.
Yes, sir, I'm sorry.
Yep.
Mr. Williams, what is he pleading to? Is it a felony?
No, ma'am. I believe this is the one that we agreed that he was going to be pleading to the lesser, Your Honor, if you...
It's just, I was asking about the score sheet. That's
No, we
all.
don't need a
Okay,
score
thank
sheet
you.
on it, I don't believe.
What are we doing with count one?
Judge,
Maybe I'm missing something.
okay, no, this is the one where it is, we are going to need a score sheet.
Okay.
Sorry, Judge, some of these are being done at the...
No, that's fine.
And I did not have a separate copy for my use. There we go, Judge.
Thank you, sir. Mr. Cohen, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth, please, sir?
William Fred Cohen, February 22nd, 1975.
All right, Mr. Cohen, you're here in 24 CF 2396, where you're charged with possession of a controlled substance. It's a third-degree felony, punished by up to 5 years in state prison, and currently driving while license suspended, third or more, which is listed as a first-degree misdemeanor, 1 year in county jail. Do you understand that?
Sure.
Okay, and I'm looking at count 2 as part of the plea and sentencing agreement would be reduced to no valid driver's license. Is that your understanding? And 3 years probation with some other terms? Is that what you want to do today? Can I ask a quick question? The 10 years mandatory, or 10 years, 10 days mandatory county jail on the drive-on license suspended, that doesn't apply to no valid driver's license even if he was suspended at the time?
The 10 days would not apply to no valid driver's license.
I know about the time that I took the bench. It was kind of a gray area, I think, or might have even changed since then. I just want to make sure I'm not missing that part of the law. We don't do too many driver-on license suspended in circuit court. I want to make sure that we're not doing anything that we're not supposed to. All right. Mr. Cohen, did you go over this plea and sentencing agreement with Mr. Williams?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
All right. And did Mr. Williams answer all of your questions?
Yes, sir.
Are you satisfied with his advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? Did anyone force, pressure, or threaten you in any way to get you to take this plea? Did anyone promise you anything other than the terms of the negotiated bargain to have you plea? And do you understand if you enter a plea, there won't be a trial of any kind? And do you understand that you're waiving all of your trial rights, which start on page 1 and go on to page 2 of your agreement? And do you understand that you're waiving all potential defenses that you may have? All right, and what is your plea?
No contest.
No contest, sir.
Okay, and that's to the possession of controlled substance and the lesser included no valid driver's license, correct? All right, I'll accept your plea as freely, voluntarily, knowingly given. Adjudication of guilt, 3 years probation, substance abuse evaluation, and any treatment. Recommended that evaluation has to be within 30 days from today, sir. I know sometimes there's backups where they have to do that evaluation, so if there is, that wouldn't be a violation, but make sure you can show that you've done your due diligence to get that done as quickly as possible. Random urinalysis for the detection of any drugs or controlled substances for which you haven't been prescribed. Obviously, if you were to test positive for something that you shouldn't have, then that could be a violation of your probation. I know some people kind of laugh when I say that, but I've seen people fight things because they never get told that a violation or a positive UA would actually be a violation. So I want to make sure I'm saying that out loud. 615 in court costs. $50 application fee to the PD, $100 PD fee for cost of defense. I think that's everything, and this is a guideline sentence according to the score sheet that has been handed. Mr. Cohen, I'm going to need you to be fingerprinted. You're going to talk to probation first since he's out of custody. Okay, it seems like they switch it on me every time. Count 2 would be time served, since it's a second-degree misdemeanor.
Yes, sir.
All right, count 2, time served. All right.
Supervision fees are waived based on the public defender?
Yes, sir. Supervision fees are waived based on his indigency.
Thank you.
Release McLaughlin. Judge, this is likewise a plea to misdemeanors, count 1, the felony is
going to be count 3 is driving on suspended. It says misdemeanor HTO. Is it because of it's a financial only?
There's a misdemeanor version, and
If it's financial only.
What
I'm
was
just trying to
charged?
remember all these things. It's been a while since I've done so many driving unsuspended. All right, ma'am, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Release McLaughlin, February 9, 1993.
Okay, Ms. McLaughlin, you're here in 24 CF 2122, charged with possession of a controlled substance, third-degree felony, punished up to 5 years in state prison, possession of drug paraphernalia, first-degree misdemeanor, punished by a year in county jail, and drive while license suspended, which is, wouldn't that be a first-degree misdemeanor then? It'll be punished by up to a year in county jail?
Judge, that's on the possession of paraphernalia. The possession or the driving while license suspended misdemeanor is 6 months probation.
What I'm saying is, isn't driving while license suspended? Oh, is
Oddly
it
enough, not on the misdemeanor HTO is my understanding. It's always
second-degree misdemeanor? I thought anything after a first conviction of driving while suspended was a first-degree misdemeanor.
if you charge it that way.
Okay.
Just as second offense DWLS it is, Judge.
Just making sure all our documents are right. All right, Ms. McLaughlin, I've been handed this plea and sentencing agreement that has you pleading to counts 2 and 3, so that's the paraphernalia and the driving on suspended license, with the state dismissing the possession of controlled substance, and you'll do a year of probation, no driving without a valid driver's license, and some costs, substance abuse evaluation and treatment. Is that what you want to do?
Yeah, you talked to probation about it.
Okay. All right, did you go over this form with Mr. Williams, your attorney? Did you understand it? Did you sign it? And did he answer any questions if you had any?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
All right, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or
No, sir.
concerns? Has anyone forced, pressured, or threatened you to take this plea offer? Has anyone promised you anything other than the terms offered in the plea bargain as a reason to get you to plea? Do you understand that by entering a plea, there won't be a trial of any kind? And do you understand that you're giving up your rights to a trial, which are on page 2 of the agreement that you signed?
Yes, sir.
Do you understand you're waiving all potential defenses that you have? All right, and what is your plea as to the paraphernalia and the driving while license suspended?
It was no contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. There's no score sheet because it's just misdemeanors. State have an announcement on count 1.
Dismissed.
All right. Count 2 will be an adjudication of guilt, 1 year probation. Count 3, adjudication of guilt, 6 months probation, concurrent to count 2, no driving without a valid driver's license, $300 in court costs, substance abuse evaluation, and any treatment, misdemeanor PD fees, so that's 50 and 50?
I believe so, Judge.
Okay, and court costs are 300. All right, so just to make sure it's clear, all the terms were listed under only count 3, but they're concurrent with count 2 as well.
Yes, sir.
Otherwise, if you don't get something done in the first 6 months, they could violate you if it's not part of the year long too. All right, any questions? All right, step over and talk to probation, and you have 30 days to appeal the judgment and sentence.
Thank you, Judge.
Yes, sir, thank you. Fees are waived. Supervision.
Judge, let me recall Thomas Heder-Shide. Judge, I have no earthly idea what's going on. I'll ask my secretary to get a hold of him. I've got one other gentleman that misunderstood and thought that all PD court dates were going to be starting at 1, and so we've had to get a hold of him and get him on his way.
Didn't you say Heder-Shide was here earlier?
I'm talking about somebody else, Mr. Hutto.
All right, well, I mean, as long as they're here before we finish up. Who's that?
Mr. Hutto? Oh, okay, I didn't see here. Come on up, Mr. Hutto. Judge, I spoke with the state about this case as well as many others on Friday, and Mr. Hutto's asking for a continuance. I believe the state was wanting one as well. This is one of the ones that was Justina's.
State?
Yeah, this was not set for,
It wasn't set for trial.
right. I don't, no objection. Just want to make it clear, the state was not asking for a continuance, but
Yeah,
it's
I've
not
got a
objecting.
clear continuance.
Yeah.
All right. So there'll be April 28th at 1 o'clock, Mr. Hutto. We'll see you
Thank
back
you,
on that
Judge.
date. Stay in touch with your lawyer.
Judge, everybody else that I have is incarcerated.
You want to handle some of them, or?
I can if they're lined up. Oh, wait, that's not true. I do have some still out. I'm sorry.
Evidenced by all the hands in the back row going in.
Judge, let me call Marcus Hamilton.
You raise your right hand, sir. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Your name and date of birth?
96.
And Mr. Hamilton, you're here in 24 CF 2014. You're charged with 4 counts of failure to register, which are 5-year maximum incarcerative sentences based on being third-degree felonies. Do you understand that? I've been handed a plea and sentencing agreement that calls for you to plead to counts 1 and 2 with the state to dismiss 3 and 4, 2 years of community control followed by 3 years probation. Is that what you want to do? Oh, I'm sorry. 2 years community control followed by 3 years probation and then another year concurrent probation. Is that right?
Yes, sir.
So it's basically 2 and 4. Yes, it's consecutive. I didn't notice that until I got to the second line. I apologize for that. All right, is this the state's agreement? Okay, and is it the state's agreement to do a downward departure where he scores 52.05 months in state prison? Is this what you want to do, Mr. Hamilton?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer, Mr. Williams? Did you understand it? Did you sign it? If you could speak up just a little bit between
Yes,
all
sir.
the noise. I don't think a lot of people can hear it, but there's some noise that comes from back where the inmates are. Are you
you satisfied with Mr. Williams' representation?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to get you to sign this? Has anyone promised you anything other than the terms of the agreement that you've made with the state in order to get you to promise to do this? Okay. You understand there won't be a further trial if you enter a plea? Do you understand that you're waiving all of your trial rights, which are on page 1 going on to page 2 of the agreement you signed? And do you understand you're waiving all potential defenses that you may have? All right, and what is your plea to counts 1 and 2? And state's announcement on 3 and 4. State dismisses 3 and 4. I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on both counts. On count 1, it'll be 2 years community control followed by 3 years regular reporting probation with a GPS monitor. Count 2 is 1 year of probation consecutive to count 1 with the GPS monitor, which means you'll end up doing 2 years of community control and then 4 years of probation.
Yes, sir.
Waive cost of supervision due to the fact that you're indigent and being represented by the public defender. GPS $1 a day. Okay, court costs will be $817 in court costs. Is that with the PD fee and everything? Oh, and then PD fee will also be $150 plus a $50 application fee. Anything else from Mr. Hamilton?
I'm going to get paperwork on all those fees, sir.
They're going to talk to you at probation right behind you. You're going to be fingerprinted, and then you have 30 days to appeal the judgment and sentence. Again, this was a downward departure based on uncoerced plea bargain with the state.
Judge, next would be Christine Hamilton. Judge, on the 28th, I attempted to reach the witnesses that Ms. Hamilton provided to me. I was not able to for different reasons on different witnesses. I have since given her some business cards. I'm going to move to continue the case. She's going to have them call and schedule appointments with me. I did file a reciprocal listing those witnesses, even though I hadn't spoken to them.
What's her name again?
Christine Hamilton. It's 4624 CF 1263. No, excuse me.
1263.
Yeah, that's Ms.
it.
Hamilton. That's correct. If you'll recall, this is one that I wanted to pass it today to try to talk to the witnesses.
Okay. State.
No objection.
Listen for plea or continuance. All right. April 28th at 1 o'clock. Be back on that date, ma'am. Stay in touch with him. Obviously, you can only explore the witnesses that you give him the contact information.
Sir, may I say something? Okay, like, I was
Don't
just
talk
wondering-
about the facts of your case. But
Excuse me?
don't talk about the facts of your
Yes,
case.
sir. How would I go about, like, getting a new lawyer? Because I don't feel like he's representing me correctly. I mean, like,
You can ask for something called a Nelson hearing,
mhm.
and then you'd have to tell me why he's been ineffective in representing you, and then I can potentially appoint a different lawyer to you. But I can't just
I understand.
do it because you want one. You have
Yes,
to.
sir, I
you
understand.
have to make a written request for that.
Okay, thank you.
All right. Thank you, Ms. Hamilton.
No, one more. Candace House. Judge, this is one that was originally Ms. Turner's. I sent the prosecutor some information indicating that she completed some conditions recently on another matter to see if she still wanted all the things that were being asked originally. Other than that, I think we have an agreement. You pass it for a couple of minutes for me to go over with This is stuff
It's always
I-
been my case. I know. If you can pass it,
just for a little bit today.
yes.
All right, Judge, if I can just have her have a seat, and
All right, Ms. House, we'll call you back up once they've decided what they want to do. Next case.
About 4 or 5. Judge Charles Russell, Public Defender's Office. Lacey Alford, case number is 24 CF 1812. Ms. Alford is present and approaching. Judge, this case came in on the 24th for pretrial conference and was passed to today because Ms. Alford was not present. It was passed so that we could get her here and avoid a capias, so she's here today.
What are we doing with Ms. Alford today?
We're asking for a continuance, Judge, to the April 28th pretrial conference.
No objection from the state.
Ms. Alford, make sure you stay in touch with your lawyer. Is it going to be you, Mr. Russell, or someone else?
It'll probably be somebody else in the office, Judge, but she has come into the office. She stayed in touch with me while I've had the case.
Okay. All right, April 28th, ma'am, just make sure you reach out to them so you know who your lawyer is going to be.
All right, thank you.
And then we can start working on your case. Thank you.
Michael Bell. Bell is present and approaching. Case numbers are 24 CF 1340 and 24 CF 1355. Judge, on both cases, we're asking for a continuance to the next pretrial conference date. My review of the files show that no depositions were taken.
No objection from the state.
All right, have any attempts been made to set depositions?
Judge, as soon as we get the cases reassigned, I'm going to let the person know, whoever it is, to go ahead and get on that.
At this point, we probably don't know which lawyer is handling the case from either side. April 28th, 1 o'clock, Mr. Bell, stay in touch with the Public Defender's Office. We'll see you back on that date.
Elijah Falls. Falls is present and approaching. Case number is 24 CF 2112. Judge, on Mr. Falls' case, we're going to ask for a continuance. Depositions weren't taken, but the other issue that we're having is that because it's a possession of controlled substance and the offer that the state's made, there's going to involve a driver's license suspension, so we're going to try to work around that. So we're asking for a pretrial conference of April 28th.
All right, Mr. Falls, it's going to be April 28th at 1 o'clock. Be back on that date. Stay in touch with the Public Defender's Office.
Judge, next I want to call Sean Falk. He's in custody, but he's in DOC in Milton. Case number for the record is 23 CF 1946. Court had set this case for a calendar call today. The history of the case is that Mr. Falk had a VOP hearing, sentenced, notice of appeal was filed. PD2 then filed a motion to correct some sentencing errors. So if we could set the hearing date, then I can do a motion in order to transport and have him here from Santa Rosa.
It was like a 3800B on the sentencing.
Yes, sir. I think there's some score sheet errors and prior record. I'll get with whoever the state attorney's going to be, but I was just going to set it for hearing today and then, like I said, do a motion in order to transport. He's on page 18 of my docket.
Mr. Ross, what's the motion you intend to be heard?
PD2 file a motion to correct the sentencing error. I had to get a copy off the bench. But if you look at the motion, is it going to be yours?
It is mine.
I'll get with you, or whoever's going
That's
to have
fine.
the case will get with you.
That's fine.
What date did you want, Mr. Russell?
I thought I heard you say that March 27th is full, so
It's not full as much as I didn't want to set lengthier hearings on it.
the errors are, the state's going to have to prove the prior convictions on the score sheet. That's one of the errors, and I don't know if that's going to involve some time, so I would ask for a longer hearing date. April 8th, maybe?
I'm reading in the motion, 60 days in which to rule on this motion, which was filed on February 17th.
Okay. I'll defer to the court, Judge. Like I said, the only thing I had to do is get him here.
That March date real quick.
Okay.
Let's do the April 10th date at 2 o'clock after the arraignments.
Thank you, Judge.
27th, it's just getting too full for anything more than a kind of quick hearing.
Okay. Next case, Judge, is Mark Fonte. Mr. Fonte is present and approaching. Case number is 24 CF 2899. We have a plea agreement. It's going to involve pleading to a misdemeanor, so there will not be a score sheet, if I may approach.
Yes, sir. Right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, sir.
All right. Can you state your full name and date of birth, please?
Mark Brian Fonte. I was born on February 21st, 1969.
All right, Mr. Fonte, you're here in 24 CF 2899, charged with possession of a controlled substance, third-degree felony, punished by up to 5 years in prison. You understand that?
Yes, sir.
Can you not lead on the podium? I've been handed a plea and sentencing agreement for lesser included of paraphernalia, first-degree misdemeanor, adjudication of guilt, and some costs and fines. Is that what you want to do today?
Yes, Your Honor.
Is that the state's agreement?
Yes, Your Honor.
All right, Mr. Fonte, did you go over this agreement with your lawyer?
Yes, sir, I
Did you
did.
understand it?
Yes, sir.
Did you sign it?
Yes, sir.
And are you satisfied with Mr. Russell's representation?
Yes, sir.
Are you currently under the influence of any controlled substances, alcohol, or drugs?
No, sir.
All right. Are you currently suffering through any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement?
The matter of my cell phone, I think they were going to replace my cell phone that didn't make it to the jail with me.
What that is, Judge, is a separate issue. I don't know if the state's aware of this, but I got some emails that apparently during his arrest, cell phone was confiscated, laid on the hood of a car, and then they forgot to pick it up and whatever. So he's going to have to file a claim with the sheriff's department, but that'll be separate from.
You understand, it has nothing to do with this court case, right, Mr. Fonte?
Well, I did file a claim and they had timed it to
I
this
understand,
case.
but I'm not adjudicating that claim
Yeah.
today as part of this. You understand that?
Yes, sir.
Okay. It wasn't on the dash cam or anything flying off?
Body cam, he looked at body cam footage.
I had a case once. They'd left like the wallet on the hood during a DUI, and the kid just stayed there for like 2 miles. They pulled over and picked it up off the hood. All right, Mr. Fonte. So you understand the phone's not part of this?
Yes, sir.
Okay. You understand there won't be a trial of any kind if you enter a plea?
I do, sir.
You understand that you're waiving your trial rights, which are listed on page 2 of the agreement you signed?
Yes, sir.
And you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And what is your plea to a lesser included offense of
No
possession of
contest.
paraphernalia?
No contest.
All right. I'll accept your no contest plea to the paraphernalia charge, adjudicate you guilty, time served, court costs of $270.
$500 fine. Does that change court costs? Okay, sometimes, I remember at some point, fines would end up leading to a surcharge on the court costs, so.
No problem.
Okay. They're gonna tell you what your ultimate number is, but on all legally required court costs, pay those within 90 days. That'll also include the $50 cost of prosecution and $100 PD fee.
Yes, sir.
Any questions?
No, thank you, Your
All
Honor.
right. You have 30 days to appeal the judgment and sentence of the court.
All right.
This is a misdemeanor, so there's no guidelines.
In my last case, Judge, is Jeremy Freeman. Mr. Freeman is present approaching case number 24 CF 2639. Mr. Freeman pled Wednesday. There was an issue that Mr. Berry brought to the court's attention about Mr. Freeman's probation. He's not on your docket, but we were going to go ahead and clear that up today. I believe what probation had proposed is change supervision of the probation from DOC to JCS.
All right, then I think this is the kind of,
That's based
we've had a lot of trouble figuring out these when they're out of state and depending on the circumstances. And I thought Mr. Freeman, we thought you were going to be picked up and then they give you a bond from Alabama. Is that what happened?
Well, I believe it was a non-extraditionary, like a small level warrant for like an unpaid ticket, I guess. So I got out that night and I talked to the probation people and they told me to be here this morning to change it to.
I think we just want to make sure everything was working out right. So it's not extradition, but are you moving back to Alabama?
Sir.
You understand they could potentially serve that with you then? It's
Yes,
just-
sir. I'm going to take care of it.
They're just not going to pay for you to be transported back is what the non-extradition really
Yes,
is.
sir.
All right, so we want it changed to what now? First of all, can you handle this without, since it's not on the docket?
Change it from
Your
DO.
Honor, I'm sorry.
Go
Your
ahead.
Honor, we discussed it several times when he first came up. If he is placed on probation with misdemeanor probation, he can go back to Alabama. They don't require the same conditions we do of having to see them at home and verify residence and stuff.
Was this one where there was a concern about, it wasn't a DUI, right?
There it was.
It was.
It was brought to our attention that he couldn't be placed on mail-in supervision.
But he can report differently through JCS than he can with y'all? Okay. I just want to make sure it's clear, otherwise someone's going to violate you, and we don't want that to happen if it shouldn't. That's why we're here talking about it again.
Yes,
All
sir.
right. So he'll be amended to be JCS probation.
That was 11/29.
11 months, 29 days. Does he have the information to reach out to them?
She's
Or
getting
you
them.
grabbing one of the cards right now? Thank you, Melanie.
And Judge, he's going to go check in with him today. As soon as he
doing
leaves
right
here.
now when I
today.
leave here. Yes, sir.
All right. Thank you, Mr. Freeman.
Yes, sir. That's it. I don't see nobody.
You talk to them real quick, go around, but then they're going to send you over to JCS.
Judge, this is Joseph Carroll. Case number is 24 CF 2383. This was rescheduled for today because we needed to discuss a video visitation issue with the court. If we may approach. Just stay right here.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed. and insured, family-owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
All right, Mr. Carroll. So the issue is it's about contact, and we need some clarification
I wasn't the judge who handled that hearing back in October, so I don't know exactly what was said, so I can't really clarify something I didn't do or say. But I can go back and listen to the recording of it and see if the judge at the time had any inkling. Otherwise, we're just probably going to set it for another hearing to clarify these things so everyone understands what's allowed and what's not allowed. In the meantime, you're not to have any contact with any child who isn't at least your biological, if not also legal child. You understand me? All right, so no stepchildren, cousins, nieces, nephews, nothing like that. All right, so only if they're your biological child and that you're on their birth certificate, because frankly, I'm concerned about, when people have children together and are not married, the law says that the biological father is not the legal father unless he's been adjudicated such by a court, even if you're on the birth certificate. There's a presumption. I just came from a family law division where I probably advise this once a week, if not more, especially in an injunction court. So I'm telling you, I don't make the laws. I just have to make sure everyone understands what they are when we're dealing with them. So we'll address all those things. But as far as the current supervised contact via phone with your own children, if you're not on the birth certificate, it's not going to happen. And that will be readdressed once we come in for the hearing.
And Judge, we're going to pass Mr. Carroll's case to April 30th for now.
April 30th at 9 o'clock will be your next court date, Mr. Carroll.
Judge, I had inadvertently stuck some folks in with the jail clients after they signed this morning. George King.
You didn't stick them in the jail, did you?
Excuse me?
You didn't stick them in the jail, did you?
No, in the same part of the bucket as my jail clients. I put them in alphabetical order instead of where they were.
Okay, who's this?
Judge, this is going to be a plea on misdemeanor.
All right, Mr. King, raise your right hand. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your name and date of birth, please? Can you pull that microphone over to him a little bit more, Mr. Williams? I could hear you. I just want to make sure it got on the recording.
Sure. It's George King. Birthday is July 24th, 79.
All right. Mr. King, you're here in 24 CF 2209, charged with possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison. Do you understand that? All right. I've been handed a plea and sentencing agreement for a lesser-included offense of drug paraphernalia. Calls for adjudication of guilt, 1 year probation, some fees, and then defendant's choice of substance abuse evaluation and treatment. I'm not sure what that means.
Well, is that or ECLC, Judge?
Okay.
Emerald Coast Life Center.
All right. Because you have choice of and then or ECLC. I just want to make sure it's clear. So he's to do a substance abuse evaluation and recommended treatment or ECLC.
Yes, sir.
All right. State's agreement.
Yes, Your Honor, it is.
All right. Mr. King, did you go over this plea and sentencing agreement with Mr. Williams?
Yes, Your Honor.
Did you understand it?
Yes.
Did you sign it?
I did.
All right. And are you satisfied with Mr. Williams' advice and representation? Yes?
Yes, sir.
It's just hard to hear you still.
Yes, sir.
All right. And are you currently under the influence of alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues or concerns?
No.
Has anyone forced, pressured, or threatened you in any way to enter this agreement?
No.
Has anyone promised you anything other than the terms of the agreement to get you to plea?
No, sir.
You understand that if you enter a plea, there won't be a trial of any kind? Excuse me. And do you understand that you're giving up your trial rights, which are on page 1 of your agreement, continuing on to page 2? You understand you're giving up those rights?
Yes, sir.
Okay. Do you need to look at it again?
No, I'm good.
Okay. I just want to make sure if you need more time, we'll certainly give it to you. All right. And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
All right. And what is your plea to the lesser included offense of paraphernalia?
No contest.
All right. I'll accept your no contest plea to the paraphernalia charge, adjudicate you guilty, 1-year probation. Is that with Department of Corrections?
Well, Judge, it's a misdemeanor probation, but because it's being done in this court, it would be with state probation.
Well, except it can be done with JCS, Mr. Williams. That's why I'm asking if it's not specifically enumerated in the report or the agreement that I ask, because sometimes people want JCS, some people want DOC. I want to make sure that we're covering that. So it'll be with the Department of Corrections. Misdemeanor court cost of $270, $50 PD fee, $50 application fee, and then you're to do a substance abuse evaluation and any recommended treatment or ECLC. That's to begin in the first 30 days of your probation, Mr. King.
So that's not with misdemeanor probation, that's with felony probation?
Yes, that's why I asked the question. It used to be you could only do your probation in felony court, even if you pled to a misdemeanor, to Department of Corrections probation. However,
I'd rather it be misdemeanor because the fact that my house is being remodeled, so I'm kind of bouncing around as far as my place to live right now until it's done. Then I'm selling the house because my dad had recently passed away.
Any concerns with it being JCS probation?
Not with us, Judge.
State?
No object.
Okay. I don't have an issue one way or the other. I just want to make sure that it's clear, because we've had a couple of cases recently where it maybe wasn't clear, and then the person didn't know who to report to and those sorts of things, and they're going to explain that to you right now. So it'll be probation with Judicial Corrective Services. They're going to give you a card with a QR code, and then you have to report to them. Is that typically done same day? Mr. Barry, do you know?
To my knowledge, yes, sir.
Okay. So they're going to give you that and get set up with it today.
Okay.
All right, this is a misdemeanor, so there's no guidelines. You have 30 days to appeal the judgment and sentence of the court. Make sure you set everything up, including if you have to report with JCS if they tell you today.
Thank you.
No problem, man.
As fun as the
Judge, next one is Benjamin Lee King. Judge, this is going to be all process to count 1. You'll plead 2 and 3. There'll be adjudication withheld on those 2 running concurrently on your probation. Count 2 is still a felony, so he'll be with DOC probation.
Did I sign it, Mr. Williams? I did.
Yes. Who's pleading to all 3 counts?
No, Judge, he's pleading 2 and 3. Count 1 is to be dismissed.
Oh, that's NP. Okay.
Yes, sir.
It looked like a 1YP. I thought it was saying 1-year probation. So
sorry.
It's okay. I'm just making sure I got it right. That's why I was a little bit confused. All right, so it's just 2 and 3?
Yes, sir.
All right. Mr. King, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Please state your full name and date of birth, please.
Benjamin Lee King, 9/10/87.
Mr. King, you're here in 24 CF 735, where you were charged with fleeing and attempting to elude, and drive while license suspended as an habitual traffic offender. Those are both third-degree felonies, punished up to 5 years in state prison, as well as drug paraphernalia, which is a first-degree misdemeanor, punished by up to a year in county jail. Do you understand that's what you were charged with?
Yes, Your Honor.
All right.
I've got a plea and sentencing agreement that counts for the state to dismiss count 1. And on counts 2 and 3, it would be a withhold, 1-year probation, court costs and fees to be concurrent. Is that what you understand it to be?
Yes, Your Honor.
Is that what you want to do today?
Yes, Your Honor.
Is that the state's agreement? Yes. All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
Are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues or concerns?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the plea agreement to get you to enter your plea?
Anybody made any promises other than what the plea
No.
agreement calls for?
Okay. And do you understand if you enter a plea, that would be a trial of any kind?
Yes.
And do you understand you're giving up all of your trial rights, which are listed on page 1 and page 2 of the agreement you signed?
Yes.
All right. And you understand that you're waiving all potential defenses that you may have?
Yes, Your Honor.
Do you understand that if you plead to a driver while license suspended, that can be used against you for one of your potential 3 strikes towards habitual traffic offender?
Yes.
Okay. So if you're already on that status, this may continue that for another 5 years. Do you understand that?
Yes, Your Honor.
All right. And what is your plea?
No contest.
No contest.
I'll accept your no contest to the driver while license suspended and possession of drug paraphernalia, withhold adjudication, 1-year probation, concurrent. Court costs, is it still $270 even with traffic? Oh, I'm sorry, thank you. Count 2 is still a felony, so that will be $515, and the PD fees will be $150 PD fee and application. Anything that I've missed? All right, you got check in with probation. You've got it's with Department of Corrections who's sitting here. You've got to be fingerprinting because it's a drive-on license suspended. You have 30 days to appeal the judgment and sentence of the court. So if it is a felony on count 2 still, do we have a score sheet? Benjamin Lee King.
I need just to amend.
Is he going to score on that?
No.
So it won't be a downward departure?
No.
Okay, so. Hand that up when you're done fixing it, and I'll sign it. All right.
Supervision fees waived based on the public defender.
Yes, sir. Supervision fees waived. Go talk to probation. They're also going to do your fingerprints first. And then go over and talk to probation again, 30 days to appeal the judgment and sentence.
Javers Johnson. Two cases on Mr. Johnson. One of them was a fugitive from justice case of the state in this county charges when they have a case in another state. That other case has been resolved. I believe they're going to be announcing a null pros on the juvenile fugitive from justice count. And here's the score sheet. We're just entering a plea to the aggravated, it was an aggravated child abuse. He's actually entering a plea to the lesser offense of child abuse.
This is the previous score sheet. Yes.
That's correct. He'll be playing LIO to 827-03.
Mr. Johnson, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Javers Johnson, January 7th, 1994.
Mr. Johnson, you're here in 23 CF 2553, currently charged with aggravated child abuse. Do you understand that? Do you understand it's a first-degree felony punished by up to 30 years in state prison?
Yes, sir.
I've been handed a plea and sentencing agreement calling for a lesser included offense of third-degree felony child abuse, withhold adjudication, and 5 years probation with some other terms.
Sir.
Is that what you're wanting to do? Is this the state's agreement?
It is, Judge.
Is there anything the state wants to put on the record as to why the case is being reduced and being offered a withhold and probation?
Judge, may we approach?
Sure.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
All right, Mr. Johnson, have you gone over this plea and sentencing agreement with Mr. Williams?
Yes, sir.
Do you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
Did Mr. Williams answer any questions if you had any?
Yes, sir, he did.
Are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
And has anyone forced, pressured, or threatened you in any way to get you to accept this plea?
No, sir.
Has anyone promised you anything other than the terms of the negotiated bargain that you've made with the state in order to encourage you to or entice you into pleading?
No, sir.
And do you understand if you enter a plea, there won't be a trial of any kind?
Yes, sir, I do.
And do you understand that you're giving up your trial rights, which are on page 1 and going on to page 2 of your written agreement with the state?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have to this charge?
Yes, sir.
Do you understand all the conditions that are part of your probation as part of this agreement?
Yes, sir, I
Do you
do.
have any questions about any of those?
No, sir, I don't.
Do you understand that this would mean that you can't have any contact with your child?
Yes, sir, I do.
And what is your plea?
No contest.
I'm going to accept your plea and the negotiated sentence to the lesser included of third-degree felony child abuse, withhold adjudication, $515 in court costs, $150 PD fee, 5 years probation, no contact with your child, COJ. That means no contact. It means no indirect contact. Don't tell anyone to pass along any messages or anything like that. Do you understand that?
Yes, sir, I do.
All right. Also, use no corporal punishment with any child. Anger management class, parenting classes, comply with any and all Department of Children and Families or Family First Network recommendations for safety plans or parenting plans as given. There isn't a pending dependency case, is there? But not judicially? Okay. So that would usually be a safety plan as opposed to a case plan for a dependency case. All right. This is, again, the state's agreement and a guideline sentence. All right, Mr. Johnson, step over and speak to probation. You have 30 days to appeal the judgment and sentence of the court.
I get a announcement on 4624 CF 505, the fugitive from justice case relating
And Your Honor, the initials on the kid was D-O-J?
C-O-J.
D-O-J?
C
C.
as in
Oh,
Charlie.
Charlie, Oscar, Juliet.
And supervision fees are waived.
Yes, sir.
Thank you. C-O-J.
Thank you, Judge. Ariana? Can we do something? Active, even though he's resolved. Case over in Alabama.
He has, so we dismiss it.
No, you're talking about him.
Your Honor, the state dismisses that fugitive from justice case. Apparently, the case has been resolved.
Okay, and that's going to be 24 CF 505. State announces a dismissal. No pros.
Thank you, Judge. Candace House?
All right, what did we figure out on Ms. House?
We've got it.
All right, Ms. House, can you raise your hand? You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Candace Nicole House, 120391.
All right, Ms. House, you're here in 23 CF 1988, currently charged with dealing in stolen property, second-degree felony, punishable up to 15 years in state prison, and grand theft motor vehicle, which is a third-degree felony, punished by 5 years in state prison as well. Do you understand those current charges?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that calls for an adjudication of guilt, 2 years probation, substance abuse evaluation and treatment, or ECLC, some costs, and no contact with the victim. Is that what you want to do?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right. All right, Ms. House, did you go over this agreement with your lawyer, Mr.
Yes, sir.
Williams? Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Yeah, are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Did anyone force, pressure, or threaten you in any way to enter this agreement?
No, sir.
Anyone promise you anything other than the terms of the agreement in order to entice you into pleading?
No, sir.
You understand if you enter a plea, there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are on page 1 and 2 of your agreement?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
And what is your plea as to the dealing in stolen property and grand theft auto?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. Adjudicates you guilty, which means you're a convicted felon. Do you understand that?
Yes, sir.
All right. 2 years probation. Substance abuse evaluation and treatment. You may enroll in ECLC in lieu of that evaluation and treatment if you so choose and are accepted by ECLC. $515 in court costs, $100 cost of prosecution, $150 in PD fees, and no contact with the victim who is, do we have a name of the victim in the case?
The victim is Mr. Virgil Hunter.
Virgil Hunter, so no contact with Mr. Hunter. All right, and this is a guideline sentence.
Yes, it is.
Probation fees will be waived due to the fact that she's indigent and represented by the public defender. All right, thank you, Ms. House. I need you to step over, be fingerprinted. You're going to talk to probation before you leave, and 30 days to appeal the judgment and sentence.
Anybody else with Jay Williams that's sitting out in the gallery? Yeah, okay. Judge, he's asked me to try to speak with the prosecutor and the public defender in the Santa Rosa case. So if we can pass him out again, I'll try to get him in for an early plea if I can get everybody to agree to run everything together.
Yeah, it wasn't set for plea or trial, so it's fine.
I've got his plea or continuance for that purpose.
Yeah.
All right, Mr. Higgins, your next court date's going to be April 30th at 9 o'clock.
Thank you, Judge.
Are they trying to bring him back to Santa Rosa to handle any court dates between now and then?
He's got a capias.
So we'll handle everything here and then it'll be sent over.
Yes, sir.
All right, thank you, Mr. Higgins.
All right, Judge, my last communication with the state was they were going to reach out to the officer. I don't know if they've had time to do that, though.
When was that request made, Mr. Williams?
I just want to talk with Ms. Leone on Friday.
No, I didn't know. No, he's.
This is 2 VOPs, and then the new case is the battery on law enforcement.
Yes, sir. The battery, this is one where the battery on the law enforcement consists of my client's nose touching the officer's chin.
We did speak about it, but I haven't had the chance to call the law enforcement officer, Your Honor. We spoke about it Friday afternoon.
If you can put him on for call on a VOP date, maybe we can get a resolution by then.
It should be fine. Yeah, yes, if possible.
It does look like the new law violation is first time up, Judge.
I don't have a problem moving the date so they could figure it out. It's just a matter of where to put it.
Yes.
You want to put it on March 27th in the morning?
That's fine with me, Judge.
March 27th, 9 a.m. See if the state can speak with the alleged victim officer.
All right, thank you, Judge. Okay.
Any chance to speak with you?
Not today. Judge, this case was on for trial. I spoke with Mr.
What's
Henderson.
his name and Mrs. Henderson?
Oh, Zachary Joe Henderson. Two cases, 4623 CF 296 and 24 CF 788. And it's a plea, Judge.
Okay.
It's a plea to a lesser on one of the counts.
So it's attempted aggravated battery as opposed to just aggravated assault?
No, Your Honor, it's attempted aggravated battery.
Okay. Is there a reason why it would be attempted aggravated battery instead of aggravated assault, which is an attempted battery?
Well,
I mean,
Your Honor,
there might be a reason as far as sentencing purposes or.
I could provide the court with case law stating that there is a difference between ag battery and attempted battery or aggravated battery and assault.
Okay. All right, Mr. Henderson, can you raise your right hand? Do you swear or affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, Mr. Henderson, you're here in 24788, currently charged with aggravated battery on a law enforcement officer, which is a first-degree felony and punishment up to 30 years in state prison with a minimum mandatory of 5 years state prison. You also have 23 CF 296, which is a violation of probation. Do you understand that? Do you understand that's what you're charged with?
Not to attend it.
Do you understand
Right.
that's what you're currently charged with?
Yes, sir.
All right, I've been given a plea and sentencing agreement that would call for you to plead to an attempted aggravated battery on a law enforcement officer, which would mean that there's no minimum mandatory 5-year sentence based on the state reducing the charge. And on the VOP, you would be admitting the violation of probation. Is that what you want to do today? And it calls for 27.15 months in the Department of Corrections. That's your understanding? Okay. Did you go over this plea and sentencing agreement with your lawyer, Mr. Williams?
I did.
Okay. And did you understand it? Say again?
I understand.
Okay. And did you sign it?
Sure.
Are you satisfied with Mr. Williams' advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to get you to take this plea?
No.
Has anyone promised you anything other than the charge reduction and the agreement in order to get you to plea? And do you understand if you enter a plea, there won't be a trial of any kind? And do you understand that you're giving up your trial rights, which are on page 1 and 2 of your agreement that you've signed?
Yeah, I understand.
Say again?
I understand.
Just when you move away from the mic, it's kind of hard to hear you. All right, do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
Oh, and I'm sorry, you have a violation of probation as well, so you understand there won't be an evidentiary hearing where they'd have to prove that you violated your probation?
Yes, sir.
Okay. Okay. Thank you, sir. This is a guideline sentence. And
should
state,
be your-
yeah, 27.15?
Yes,
And this is the state's agreement?
it is,
Okay.
Your.
All right, Mr. Henderson, how do you plead to the attempted aggravated battery of a law enforcement officer?
No contest.
Right. And how do you plead as to your violations of probation? Are you admitting or denying you violated your probation?
I admit it.
Okay. I'm going to accept your no contest plea to the attempted aggravated battery on a law enforcement officer in 24 CF 788. And as far as the VOP, I'll accept your admission as freely, voluntarily, knowingly given. As to the 2 misdemeanors, that's the no valid driver's license and reckless driving. Those will be time served. As to the 2 felonies, which is the attempted aggravated battery on a law enforcement officer, as well as the VOP for the fleeing and attempting to elude, you'll be given 27.15 months in the Department of Corrections with credit for time served. They're to be run concurrently. $967 court costs, $150 PD fee. Just to make sure the state's conferred with the alleged victim in the Batleo case.
Yes, sir.
Any concerns from them?
No, no concern.
Okay. All right, and again, this is a guideline sentence. We need you to be fingerprinted, Mr. Henderson, and you have 30 days to appeal.
Your Honor, probation is revoked. And
Probation is revoked in the previous probation case.
It's outstanding monies to collection.
Yes, sir. Outstanding monies to collection on the VOP.
Judge, we still haven't gotten the materials from the state of Tennessee, so I'm going to have to move to continue. Trying to get some records on an alternative suspect, if you'll recall, from the 25th.
I do. I'm just trying to make sure I'm tracking everything with the case. All right.
Yes, sir.
So this is Mr. Joseph Horn, 24 CF 811.
No objection.
No objection. Mr. Horn, any concerns? I know I still owe you a written order from the hearing the other day on the suppression. April 30th at 9 o'clock will be your next pretrial, Mr. Horn. This case is getting a little older as well. I know there's a lot of issues with it, but let's see if we can get it resolved at the next cycle.
Yes, sir.
Thank you, sir.
Thank you, Mr. Horn.
Yes, sir. April 30th.
Unfortunately not. Was
Judge, I don't recall if this was set plea or continuance.
I have it as
It
plea or
was.
continuance.
We're still trying to get an agreement that everybody can live with.
So you're asking for a continuance, Mr. Williams?
So, yes, sir.
State have any objection?
no objection.
All right, Mr. Hudson, we'll see you back on April 30th at 9 o'clock for your next pretrial.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Mr. Jones.
Judge, this is Robert King Jones. Got a negotiated plea in this case.
All right, so this is 23 CF 2069 and 24 CF 1680. All right, Mr. Jones, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you turn the microphone to him a little bit, Mr. Williams? Yes. All right. Can you state your full name and date of birth, please?
Robert King Ray Jones, 08/18/1997.
All right, and Mr. Jones, you're here in 23 CF 2069, where you're charged with aggravated battery with a deadly weapon, second-degree felony, punishment up to 15 years in state prison. Aggravated assault, third-degree felony, and carrying a concealed weapon by a convicted felon. Those are both third-degree felonies, punishment up to 5 years in state prison. Do you understand all that? Okay. That's not what you're pleading to, but that's the maximum that you were facing. Do you understand that? All right. I've been handing a plea and sentencing agreement that calls for you to plead to that charge, be adjudicated guilty in 18.9 months, Department of Corrections. Is that your understanding? And the state, which is not a condition of this plea, is what it says, but the state will be now prosecuting 24 CF 1680. Is that right? Criminal mischief.
Oh, yes, Your Honor, yes.
All right. Mr. Jones, did you go over this plea and sentencing agreement with your lawyer? Do I have a score sheet?
I'm
You're working on it?
Yes.
Okay. This is as charged, right? Oh, no, I'm sorry. Count one is lesser included misdemeanor battery.
Yes, that's what, okay.
Mr. Williams, that's going to get used to where you put things on the plea form versus some other people. I'm not saying you're doing it wrong. Sometimes I miss it the first read. All right. So, Mr. Jones, this calls for you to plead to, instead of aggravated battery, be misdemeanor battery, the aggravated assault, and the carrying concealed weapon by a convicted felon. Do you understand that?
Yes, sir.
Okay. And you've gone over this with Mr. Williams? Did you understand it? Are you satisfied with his advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
And are you currently suffering from any mental health issues or concerns? And that's your signature on there?
Yes, sir.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement to entice you to plea? And you understand if you enter a plea, there won't be a trial of any kind. And you understand that you're giving up your trial rights, which are on page 1 and 2 of your agreement.
Yes, sir.
You understand you're waiving any potential defenses that you may have.
Yes, sir.
All right. And this is the state's agreement, and y'all have contacted the victims in the case.
Yes, Your Honor.
All right. And Mr. Jones, what is your plea as to the lesser included misdemeanor battery, aggravated assault, and carrying a concealed weapon? What is your plea? All right, I'll accept your no contest plea as to the lesser included misdemeanor battery, aggravated assault, and carrying concealed weapon. Adjudicate you guilty on all counts. 18.9 months Department of Corrections with credit for time served. They're to run concurrent, $967 in court costs, $150 PD fee. On the misdemeanor, which was count 1, that will just be time served. Okay. And was that a guideline sentence?
Your Honor, what I have here, by making the changes, it might have been I have 19.05 months. 18, I believe.
18.9.
I wouldn't mind to just,
Downward departure for 0.15 months.
yeah.
Okay. That's fine. That's about 5 days, 4 or 5 days.
Thank you, Your Honor. May I approach?
Yes.
I might have miscalculated.
Is there an issue, Mr. Jones?
I'm all right.
I just want to make sure you say it now before we.
I'm just ready to go home.
No,
That's
okay.
it. Tired of being played with.
I'm just, say again?
I'm just tired of being played with.
By whom?
Sir?
Who's playing with you?
Nobody.
Okay. I just want to make sure you've had your opportunity, since there's a little bit of a difference here, that if you had any concerns about it, they're being raised now.
But all parties should be on the same page if they talk before they talk to me. Just saying.
Well, the issue is, it sounds like the state miscalculated to give you a little bit less time than what you actually would have got under a guideline. So would you like me to make it 19.05?
Nah, it's all right.
Okay, so that's all we're talking about.
Yes, sir.
18.9 months as a downward departure plea bargain, as opposed to the 19.05. All right, you have to be fingerprinted, Mr. King, and you've got 30 days to appeal.
Kemp. Madam Prosecutor Judge, Mr. Kemp wants me to state on the record that he would like to do defense house or time served on a misdemeanor trespass.
Unfortunately, Your Honor, I cannot accept that due to the victim's wishes. I did, just for to put it on the record, I did offer a plea to the bench, offering though a cap of guidelines. Like, in other words, the state would not seek more than that. And I guess if they have some mitigating factors that the court may consider for a downward departure to allow Mr. Kemp to go to Phoenix House, then it would be after, I guess, a sentencing hearing.
Okay. And what were the guidelines that would be the cap?
Yes, Your Honor, the guidelines currently is 49.8 months.
All right. Mr. Kemp, can you raise your right hand? Do you swear, right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. So, and do you understand the plea offer that was just given?
I'm not sure.
Okay. Do you want to have time to speak with Mr. Williams about it?
Okay.
Basically, what it means is they're offering that if you plead straight up, and I make the decision on what your sentence is, it's not negotiated. I'll actually make the decision, as opposed to a plea and sentencing agreement. That your cap, the most I could sentence you to is 49.8 months. So it's just over 4 years. With credit for time served. And then your attorney with you can argue for less than that. You'd have to show reasons sufficient for a downward departure, which means you'd have to prove not only is there something that makes you eligible for a downward departure, but also you'd have to convince me that I should give you a downward departure. So even if I were to give you one less month, you'd have to prove that. Now, I don't know anything about your case, but I'll certainly listen to any arguments that could be made. Otherwise, I think we're set for trial. If you go to trial and were to be convicted, unless there's one of those downward departures, I can't give you any less than the 49.8 months. What is his maximum exposure if he goes to trial? Burglary?
Yeah.
Okay, so a potential 17 years if you go to trial and if you're found guilty of all counts. It's 15 years on the burglary, as your attorney just stated, 1 year each on each of the misdemeanors. I'm not saying what I would do if you were to go to trial and if you were convicted on anything. I'm just trying to make sure you understand all the maximums, the minimum guidelines, and understand the downward departure issue. What would you like to do, Mr. Kemp?
Okay, the Phoenix House is out the deal from the other day.
I don't think was that ever offered?
No, it wasn't offered.
I don't think that was ever an offer they made, and certainly not in open court.
We had offered.
Okay, so you suggested that you should resolve it that way. So the state is not willing to take you up on your counter offer. All right, so Mr. Kent, let me just explain one more thing. Today is typically my cutoff for negotiated pleas, which means if you come back even on Friday for our jury review docket before trial next week, I wouldn't entertain any negotiated pleas unless someone gives me some specific reason as to what happens between now and then. So you can either accept this offer today, or it would be straight up with no cap on Friday.
Judge, can we approach?
Sure.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right, Mr. Kemp, here's what I'm willing to do.
This is
We're going to
Tiffany
leave you on
Woodham,
for
State
Friday.
Farm's newest
Mr. Williams
agent
will
in-
come out and talk to you a little bit more. If you decide to enter a plea on Friday, I would still consider the negotiation, which is a cap of 49.8 months. I normally don't do that, but your lawyers convinced me there's a good reason to, so I'll keep that open for you. We'll set it on Friday as a plea or continue, so it won't be on our trial docket for some potential evaluations to be done as for sentencing purposes, if that were to happen. All right. All right. All right. Thank you, Mr. Kemp. We'll see you on Friday at 9 o'clock.
Well, Judge, I'll go ahead and set it for trial based on the defendant's wishes.
Get my ring. I had it as plea or continue, Mr.
Me too, Your Honor.
Doing my clients, he's wanting to move it along. He doesn't want to take the 180 that's been
Well,
evaluated, so I'm just trying to move it along.
It is. I got a case plan for my children. I'm trying to work. And that's the first chance I've had to be able to fight for my kids. And I'm trying to.
Well, I understand, Mr. Langley, but when we were here last week, it was announced plea or continue for today.
Plea?
That you were all going to resolve it today, or it was
Want
going to be
to.
continued. So I didn't have you listed for our trial docket.
The only thing they're trying to offer me is 6 months in jail. And the thing is, I only got a year to get my kids back. And I ain't doing that. And I can't get I can't do it. This is my only chance to get for my kids. And the reason I ain't messed up to begin with about getting this case plan going is because my old lady was a nut, and I knew it. I didn't want to bring the light on her about it. Now that the light's already out, I got to fight for my children. That's what it is. There's no ifs, ands, or buts. And
After Thursday, what's our next? That's the only thing I can think
March
of.
27th.
here to do my kid case plan. I ain't got time for it. I can't. That's my boss man right there.
That's probation.
I'm not anybody's boss man.
In the interest of trying to get him out where he is able to work the case plan, would you look at it for purposes of probation and maybe even get me an answer by Thursday? Actually, it'd be Charlie. I'm sorry.
I can
Judge.
try, I cannot promise because I got my own trial set, but I can try.
It's not been continued before. I'm just trying to expedite getting you released.
Mr. Langley?
Sir? Yes, sir.
I've already told you to turn around and not speak to probation.
Do that. No. Yes, sir. Yes, sir.
Don't do it again.
I ain't gonna do it again.
You're not, are you on probation?
Well, no, sir.
Are you on probation?
No, sir.
Then why do you keep talking to the probation officer? All right, what would you like to do with it, Mr. Williams?
I'll try, Joe.
We don't have much in the morning. Let's put on March 6th. That's this Thursday at 9:30. Just because I have RPOs that will go past 9 o'clock. All right, we'll see you on Thursday, Mr. Langley.
Yes, sir.
But I'm not sure what they'll figure out in the meantime, but we'll see what happens.
Thank you, Judge. Judge, this is Jeffrey Long. In speaking with Mr. Long, he advises me that he believes that the remaining $100 has been paid. I don't know if the state's had a chance to check it.
Your Honor, I have not because didn't have the time. We discussed it Friday afternoon, and I did send a request to my victim advocate. She may be trying this morning.
She did.
Can we pass it to Thursday then?
It's fine. Your Honor, we're trying to, yeah.
It's just $100.
I don't want to put him on probation with early term and have him get additional court costs.
Want to put it on Thursday then?
That would be
All right,
fine. Your Honor.
Thursday, March 6th at 9:30.
Malone.
Judge, this is the other case where Dr. the expert, the state asked me if I would agree to a continuance. I talked to Dr. Zeman. He's not available this docket. I'm not able to try it. So I think what we're talking about is a joint continuance.
I did file an unopposed motion to continue with the court. I copied Mr. Williams. He might not have had the chance to look at it, but it was based on my conversation with him.
This is for a second expert.
Well, it's for my expert to be available, but if the state requests a second expert, the court will have to give
This is an insanity defense.
Yes, and I also filed a motion to appoint the second expert. We can expedite it.
This would be the state's expert for purposes of trial.
Yes, this has, you mean the motion to appoint the expert?
The motion for appointment of second expert for insanity, but really it's would be the state's expert to testify at the trial regarding insanity.
I guess then you're right, Your Honor, you're correct. I called the second because he had an evaluation, but it would be, yes.
So do I need to appoint that person?
I think the court should.
Court
Yeah,
may
yes.
have to, because we We have our own process cost to hire experts. I don't know that the state.
Yeah, we normally do it via order of court.
I think this is the first time it's come up on this particular type of defense. So
I agree.
That's why I'm just making sure that,
Yeah,
all right, just, and you've already sent over an order?
I
at least
did.
as part of it?
Yes, Your Honor.
I mean, I saw it yesterday, I read it, but I didn't read through all the details of the order yet because I wanted to make sure we talked about it today.
Yes.
All right, so then it's a continuance as well.
Yes.
Will be April 30th at 9 o'clock for the next pretrial. Let's see what we can do to get the experts in line.
Absolutely, yes, Your Honor, we will do.
Thank you, Judge.
Would it help if, I mean, as we get closer, obviously, if y'all want to pick a date where it looks like the experts will line up, let's do that as soon as possible, so we don't have a situation where it's too late to get on their calendars for purposes of the trial.
Absolutely. As soon as we can contact Dr. McDonald with the order, we'll schedule that.
If it's going to potentially go to trial in May, as you know, we just set the Norris case will be the week of May 12th, so it'd probably have to be that second week.
Already asked Dr. Zeman for dates in May.
That will be fine, Your
All right. I just don't want to come back and, you know, everyone's calendars don't work because we didn't try to narrow it down early enough, because I know
Yes.
Dr. Zeman and Dr. McDonald are very, very busy.
Yes, sir.
All right.
You emailed me? Yes. You had sent me an email? Remember? But I don't remember. That was that email you were reading that you didn't remember.
Oh, yeah.
He wants what?
No, that was the original offer. Judge, this is one where we don't have a lab report back on the latest case. It's a possession, and then tracking along with it is not an introduction, but another possession from within the jail. I don't want to plead him on anything until I get the second lab report. So, Judge, if I can get it worked out early, I'll set him on a miscellaneous. I've got it as being set plea or continuance.
No, sir. Any way I can get a bond set today? Settle it right now, final 6 months. Okay.
That's fine.
Judge, I can take a few minutes and draft one up that you may or may not be able to actually read. Or simply do
I'm sure if you try
copy.
really hard, Mr. Williams, I'll be able to.
I'll try, Judge. Back on the second case yet.
That's fine.
And if you guys can bring him back out.
Good.
Yeah.
Thank you, sir.
Thank you, Judge. Yes, they are.
Gainey?
I was just trying to look at the facts of these because there was a couple floating around. I think I did one of the first appearance where it was like, or I did a warrant where he was in the jail and they found something later and they went back and looked at the video and found out it was dropped by this particular person. I was trying to understand why I didn't have a bond if they happened at the same time, but that's not the facts of his case, now that I've read it. All right. Morning.
All right,
Good afternoon. It's 1:30.
Judge, this is Ms. Gainey, and I've spoken with Gainey. I've looked over the case law she wanted me to look at. We don't get there quite the way that she wanted to get there, but I think I do have, hopefully have grounds. I'm going to have to move to continue it, though, so that we can get that scheduled and on the docket for a motion to suppress. I need to talk with her a little bit further about who we want to take the officer's deposition.
State.
Well, first, Your Honor, I'm inquiring into whether Mr. Williams is adopting Ms. Gainey's motion the way it's written, or he's going to file another one.
I'm going to file another
Well,
one.
I think she's filed 3 of them, so you'd have to pick which one.
Yes, sir.
Just a second.
She also asked me to get some surveillance footage of the area to establish one.
This is like a year-old case, right? This is like a year-old case, right? I highly doubt the surveillance. I mean, you certainly do what you can, Mr. Williams, but most places don't keep that stuff more than about 30 to 90 days.
Your Honor, just, it was a Mr. Williams case.
Oh, I understand.
Yeah.
All right, so you just want to put it on the next pretrial, file your motion or adopt one of hers, and then go from there? Get another date, Ms. Gainey? Anything that you want to say?
No, sir. Sounds good.
All right, April 30th at 9 o'clock for your next pretrial, Ms. Gainey. And then hopefully we can get that motion heard before that date.
I understand,
Ms.
but I haven't had
Grimes.
the chance to talk with the officer victim.
Judge, I'm going to have to move to continue it. I'm trying to get her an offer for probation.
Yes, Your Honor, I don't object. I just need the time to communicate with the victim.
All right, anything, Ms. Grimes?
Continue it to when?
The next date is 4:30, ma'am, but if we can get it.
Okay, my question is, how long is it gonna take to talk to the cop? Because it's been 6 months.
Well, understand that neither I nor her had this case until comparatively recently. She's had it since last Friday.
3 days.
Lack of ability to get a hold of the officer on her part.
And Ms. Grimes, just so you understand that the state is obligated to reach out to alleged victims in cases to see what their thoughts are on the case before making plea offers. It's something called Marcy's Law. It's part of our state constitution now. So they have to do it regardless.
All right.
I'll put you on the April 30th date at 9 o'clock, but as Mr. Williams said, if they come to some resolution because they're able to talk to the officer and it involves probation, we'll find a date to get it done much earlier.
Okay.
Thank you, Judge.
Thank you.
Thank you, Ms. Grimes.
That's all I got. Well, let me see if I've got an answer on Heder-Shide. And Judge, now that I think about it, I'm not certain it was today that I saw him. It might have been when he came into my office on Friday.
Is he here?
Mr. Heder-Shide? Oh, there he is. Okay.
All right, why don't you want to take him now or talk
Yes,
to
sir.
him?
Yes. Come on up, Mr. Heder-Shide. Judge, this is a negotiated plea. We have a signed plea offer in the case.
Attempted possession.
Looks like we don't need a portion from him. Thank you.
All right, Mr. Heder-Shide, am I saying that right?
Yes, sir.
All right, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Thomas Joseph Heder-Shide, April 26, 2001.
All right. So my understanding is the information says attempted possession, and you has possession. It's the same degree.
Judge,
I just want to make sure it's consistent.
The information.
Was there an amended information? Oh, no. I don't. Oh, yes, it does.
One I'm looking at was filed September 26th of 24.
Okay. Clerk's office listed as attempted. It says attempted on my docket as well. Okay. Well, I'll scratch that out.
I just see one information, Your Honor.
Yes.
September of 24.
For some reason, the clerk has it as attempted, but it's clear now that the information, that's not what it says. All right, Mr. Heder-Shide, you're here in 24 CF 2079, charged with possession of cocaine, a third-degree felony, punished up to 5 years in state prison, and no valid driver's license, which is a second-degree misdemeanor, punished by up to 60 days in county jail. Do you understand that's what you're currently charged with?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that calls for you to plead no contest to both counts for withhold of adjudication, 2 years probation, substance abuse evaluation and treatment, show proof of a valid driver's license, as well as some costs. Is that what you want to do today?
Yes, sir.
Is that the state's offer?
Yes, Your Honor.
All right. And Mr. Heder-Shide, have you gone over this plea and sentencing agreement with Mr. Williams?
Yes, sir.
And did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
Are you satisfied with Mr. Williams' representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the agreement in order to have you plea? And do you understand by entering the plea there won't be a trial of any kind?
Yes, sir.
And that you'd be giving up the rights on page 1 and 2, your trial rights, you'd be giving those up. Do you understand that?
Yes, sir.
Do you understand that you're waiving any potential defenses that you may have?
Yes, sir.
All right, this is a guideline sentence. Yes. All right, and what is your plea as to the possession and the no valid driver's license?
No contest.
I'll accept your no contest plea. Withhold adjudication, 2 years probation, $615 in court costs, $150 PD fees, substance abuse evaluation, and any recommended treatment. Show proof of valid driver's license, waive cost of supervision due to the fact that you're represented by the public defender's office. Anything that I've missed? Oh, on the misdemeanor time served?
That's fine, Your Honor.
All right, time served on the misdemeanor charge. All right, thank you, Anna. All right, step over to probation, and you have 30 days to appeal the judgment and sentence.
Thank you.
You don't need to bring something withheld.
No, that was my long pause, was trying to realize if I needed that or not.
Judge, I believe that's all the cases that I have.
All right. Ms. Rivers. Nichols is coming
Nichols
back
is coming.
after you write up that plea offer.
Your Honor, the first one on the docket would be 24 CF 1471. That would be Laura Coleman. Week, the state had asked to have her present for today to confirm the status of a program that she was in. She has since completed the program. She is out. She currently lives in the state of Louisiana. In talking with the family, what they hope to accomplish, she's going to need to meet with her new attorney to see how they best reach that goal. We're going to ask for continuance at this time.
Objection.
That'll be April 28th at 1 o'clock. All right, Ms. Coleman, stay in touch with Ms. Rivers. We'll see you back on April 28th,
Yes,
1
sir.
o'clock.
Yes, sir.
Thank you.
Thank you. Your Honor, the next one is Tanya Crooks. That would be 24 CF 1334. And Your Honor, there was an issue, I guess, that she had brought up with Mr. Gibbs. I had conveyed to her my response to that issue. I think at this point, it's going to be something that her and Landon Maddox will discuss and how to proceed. You're going to request the
28.
No objection.
All right, Ms. Crooks, we'll see you back on April 28th at 1 o'clock. It looks like your new attorney is going to be Mr. Maddox, so you'll talk to him in the meantime so he can catch up on your case. All right, thank you.
The next one is Traylon Durham, 24 CF 932. And if I may approach with the state on this one.
Which Durham?
Traylon.
Okay.
Number 42 on my docket.
It's accurate this time, but it just seems like it's always like one off from what you guys said.
You. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base.
Your Honor, based on my discussion with him, he's going to decline the state's offer at this time. He's indicated that he wants to watch videos, so we will continue this case with the court's approval to 428.
No objection.
All right. April 28th at 1 o'clock, Mr. Durham. See you back on that date. Make sure you stay in touch with the Public Defender's Office and
Yes,
talk
sir.
to Mr. Maddox. All right, next.
Your Honor, the next one is Bobby Duvall, 24 CF 2147. We are set for trial.
All right. Defense ready?
Your Honor, I had this pulled up. On February, looks like around February 11th. Let me see the exact date. February 5th of 2025, the listed victim in the case not only wrote a sworn statement where she recanted the facts, she also declines to prosecute and refuses to prosecute. So based on that, the state will announce a null pros.
All right, case dismissed, Mr. Duvall.
Your Honor, the next one I have is Diana Patricelli Freeman, be number 54 on my docket, 24 CF 1963. Now, when we were in court last week, I had discussed with the state the offer that we were going back and forth on. The state did not have that offer written down. That offer had been made by Cody Sprouse, but apparently he did not put it in writing on his end. My understanding is they still don't have an answer on that, so at this time we're going to ask the court to continue to 428.
Which case is this?
Patricelli Freeman. I have it as 54 on the docket. Is that what you said?
Yes, Your Honor.
No objection. I think it's fine.
All right, Ms. Patricelli Freeman, we will see you back on April 28th at 1 o'clock. Stay in touch with the PD's office. You may, is she going to remain yours?
No, Your Honor, that would be Landon Maddox.
All right. Even though it starts with letter P? Even though it starts with the letter P? Oh, it's a third-degree felony.
Yes, sir.
I'll figure it out eventually. All right, we'll see you back on that date, ma'am.
Go to the next one is Adam Richardson, 24 CF 78, 24 CF 2847. We reached an agreement in this matter, if I may approach.
Yes, ma'am. So a total of 3 years probation?
Yes, sir.
Okay, just making sure I'm tracking everything. There's a lot
I
to.
had to put the comma because I should have.
You know, you're good on that. I'm just want to make sure I'm tracking it and reading it properly. But no, that's what it says. I just want to make sure I got it right. All right, Mr. Richardson, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and
Yes,
nothing
sir.
but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Adam Richardson, 11/25/2000.
All right, you're here in two different cases, Mr. Richardson. 24 CF 78, introduction of contraband, 5-year maximum penalty on that as a third-degree felony, as well as domestic violence battery, which is punishable by up to 1 year in county jail. Then I also have 24 CF 2847, where you're charged with resisting with violence, battering a law enforcement officer, both third-degree felonies, punished by up to 5 years in prison, and battery domestic violence, also, again, a 1 year maximum on a first-degree misdemeanor. You understand what you're
Yes,
currently
sir.
charged
Yes,
with?
sir.
All right. I've been handed a plea and sentencing agreement that calls for a total of 3 years of probation on both cases. The count 1 on the latter case, which is resisting with violence, would be dismissed by the state. Otherwise, you're to do 3 years probation, batter's intervention, which is a 26-week course.
Yes, sir.
No violent contact with the victim, no alcohol, attend AANA on a weekly basis for 1 year. And then you have costs. Is that what you want to do today?
Costs?
Well,
Court
no,
costs. Oh, yeah, yeah,
Court
yeah.
costs, in addition to all the other things
Yes,
I
sir,
just
yeah,
mentioned. All right, is that the state's agreement?
Yes, Your Honor.
And this is a downward, no, it's not a downward, it's crossed off. Okay, so this is a guideline sentence based on the dismissal of the other charge. All right, Mr. Richardson, did you go over this plea agreement with your attorney?
Yes, sir.
Did she answer any questions you might have had?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
And are you satisfied with your attorney's
Yes,
advice
sir.
and representation?
Yes, sir.
All right. Are you under the influence of any alcohol, drugs, or controlled
No, sir.
substances? I know you've heard this 100 times, but just let me finish up so that way we don't talk at the same time on the
Sorry,
record. It's one of those, you're trying to stay ahead, but it muddles up the recording.
Okay.
All right. Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the plea and sentencing agreement?
No, sir.
All right. And do you understand that if you enter a plea, I didn't say this, it would be a withhold on all counts? Okay. If you enter a plea, there won't be a trial of any kind.
Yes, sir.
Do you understand that you're giving up your rights to a trial, which are included on page 2 of the agreement that you signed?
Yes, sir.
Do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
Has the state contacted the victim and it looks like she wants no violent contact? He? Okay. You've got it kind of scribbled over that, so I will.
Your Honor, because I originally wrote the name.
Okay. Rennie is the first name. Rennie Smith. Okay. I think it was, I'm looking at what it was initially before you marked it up. All right. I'm sorry, State, I asked you a question, then didn't get your response. At least I didn't hear it.
Your Honor, for the no violent contact.
With Rennie Smith, Reney Smith.
Your Honor, I don't see any notes regarding contact, but I do note that there was a drop charge request filed by Rennie Smith last year. I was also advised by Ms. Rivers that she had had contact with the victim, and the victim had also indicated that he wished to have no violent contact.
Okay. All right, Mr. Richardson, what is your plea?
No contest.
All right, no contest as to the 24 CF 7-8 counts 1 and 2, and 24 CF 2847 counts 2 and 3. Again, the resisting with violence is dismissed. Correct, State?
That's correct, Your Honor.
All right. I'll accept your plea. Withhold adjudication. Can you withhold on Bat Leo? Isn't that a mandatory adjudication on Bat Leo?
It may be one of those that's discretionary, Your Honor. I'd have to.
If you could just look, just to make sure. I mean, if that's what y'all have agreed to, that's fine. I just want to make sure it's not a mandatory adjudication and I do something that's an illegal sentence.
I know the resisting with violence it does not require, we're verifying the
I seem to
battery.
remember when I used to handle these cases, it was oftentimes trying to reduce a Bat Leo down to resisting with in order to get away from the mandatory adjudication.
Yeah, I believe you're correct, Your Honor. We're just checking.
I'm not saying I'm right, but I'm pretty sure that's what I remember, at least when I handled cases like this. And I just want to make sure it's not a situation where it's an illegal sentence, even if it's agreed upon.
Okay, Your Honor, I found it. Yeah.
Okay, go ahead.
It said that it cannot be a withhold of adjudication. It has to be, yeah. Resisting with. Would it still be within guidelines doing that? Because
Why don't y'all take a look at it just to see? I just don't want it to be a situation where it comes back and then he's
Yes,
withdrawing
Your
his plea. And
I would probably have to contact. And it would be a situation where we would have to contact the victim of the battery, law enforcement officer.
you want to take this back, Ms. Rivers? You can keep it for your file. Maybe you'll get it worked out. All right, so I don't mean to jam things up, but again, I've got to follow what the law says, and I don't think I can do it the way it's written up. So y'all know who the law enforcement officer victim is? If it's just someone you think you can reach pretty quickly, we can bring it back quickly, or just put it off till April? I don't mind bringing it back Thursday if you felt you can figure it out in the meantime, but.
I mean, Your Honor, I would suggest to bring it back on Thursday, and I'll write in a list of all those stuff that I need to do. I'll do this too.
Let's put it on March 6th, this Thursday at 9:30, Mr. Richardson. That way, if they can figure out that side of it, and since there seemingly is an agreement, it's just kind of the details that have to be worked out.
You'll call it.
No, you're good. I'll let you know.
All right, we'll see you back on Thursday.
Thank you. The next one I have is Samuel Roberts, 22 CF 2997. He is president of We've reached an agreement in this matter. The score sheet with that? I did.
Unsupervised with daughter, is that what it is? Okay. Your parenthesis kind of looked like an actual C, so it was kind of hard to read for a second there. All right, this is 22 CF 2997. Can you raise your right hand, sir? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right, can you state your full name and date of birth?
Samuel Allen Roberts, 6/30/1994.
All right, and Mr. Roberts, you're here charged in 22 CF 2997 with using a computer to facilitate or solicit sexual conduct of a child, which is a third-degree felony, punishable up to 5 years in state prison, as well as unlawful use of a two-way communications device to facilitate a felony, also a third-degree felony, 5 years max. Do you understand what you're currently charged with?
Yes, sir.
I have a plea and sentencing agreement between you and the state attorney's office that calls for you to plead no contest to count 2. The state would then dismiss count 1. Wait a minute. Is there more than one case? I've got it here. It says state to now process count 1, count 2, comma 3. Oh. Count 2 is 3 years probation. Okay. All right. This calls for you to plead to count 2, use of a two-way communication device to facilitate a felony for 3 years probation. Terms of that probation would be not possess or consume alcohol or drugs without a written prescription. Waive cost of supervision, $4.15 in court costs, some other PD fees, and no unsupervised contact with any minors, although you could have unsupervised contact with your own daughter. Is that what you understand to be the agreement? Is this the state's agreement? Okay. Is there anything else that you want to state on the record as to the plea agreement? Okay. All right, Mr. Roberts, is this what you want to do?
Yes, sir.
All right. Have you read the plea and sentencing agreement?
Yes, sir.
Have you gone over it with Ms. Rivers?
Sir.
Did you understand it? Did you sign it? Are you satisfied with Ms. Rivers' representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement to have you plead to the case?
No, sir.
Do you understand there won't be a trial of any kind if you enter this plea?
Yes, sir.
Do you understand that you're giving up your trial rights, which are listed on page 1 and 2 of the agreement that you signed?
Sir.
Do you understand this calls for an adjudication of guilt, which would mean you're a convicted felon?
Yes, sir.
Do you understand you're waiving all potential defenses that you may have?
Sir.
And what is your plea to count 2, the unlawful use of a two-way communication device?
No contest.
All right. Court will accept the no contest plea as to count 2. States in dismissing count 1, correct? Adjudicate you guilty on count 2, 3 years of probation. You're not to possess or consume any alcohol or make sure I say this. You're not to possess or consume any alcohol. You're also not to possess or consume any drugs without a written prescription. Sounds like you can get a prescription for alcohol. I just know that seems silly, but I want to make sure it's clear. Waive cost of supervision based on the fact that you're indigent and represented by the public defender's office. $415 in court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. No unsupervised contact with minors. You may have contact unsupervised with your daughter. Any other questions?
Yes, sir.
This is a guideline sentence. Yes. All right. Mr. Roberts, we'll need your fingerprints. You have to meet with probation before you leave here, and you have 30 days to appeal the judgment and sentence of the court.
Case is Courtney Rose, 24 CF 1647. We've reached an agreement in this matter.
Too much paper up here. Ms. Rose, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth?
Courtney Michelle Rose, 12/14/85.
Ms. Rose, you're here in 24 CF 1647, where you're currently charged with the illegal use of personal identification information, which is a third-degree felony, punishable up to 5 years, as is count 2, fraudulent use of a credit card. Do you understand that?
Yes.
All right. I've been handed a plea and sentencing agreement that calls for an adjudication of guilt on both counts, which would mean you're a convicted felon. Do you understand that?
Yes, sir.
Also calls for 3 years probation, anti-theft class, $939.85 in restitution to be paid at $35 per month. No violent contact with Joshua Lingenfelter.
Mm-hmm.
I got that
Yes.
right? And then your other fees also, it looks like you have a out-of-state conference that you're wanting permission to go to. Normally, that's something that probation just does or doesn't, or asks me later, but obviously they're trying to get ahead of it, right?
Yes.
Okay. Is that the state's agreement?
Yes, Your Honor.
And it's as charged?
Yes, Your Honor.
Okay, and it's a guideline sentence. All right, Ms. Rose, have you read this plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes.
Are you satisfied with Ms. Rivers' representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you suffer from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for the plea?
No.
Do you understand that if you enter a plea, there won't be a trial of any kind, and you're waiving your trial rights, which are listed on page 2?
Yes.
And you understand you're waiving any potential defenses that you may have had?
Yes.
And what is your plea?
No contest.
I'll accept your no contest plea as charged in counts 1 and 2, adjudicate you guilty, 3 years probation, waive cost of supervision due to the fact that you're represented by the Public Defender's Office and have been deemed indigent. You have to do the anti-theft class, $939.85 in restitution to be paid at $35 per month. Is that to Mr. Lingenfelter?
Yes, it is.
Okay. No violent contact with Mr. Lingenfelter as well. $415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee, and order for probation that she may leave the state while on probation to Nevada for a prepaid, pre-booked conference from April 27th to May 3rd of this year. All right. I need you to be
The restitution amount again?
$939.85.
Okay.
All right, and you'll need to be fingerprinted, then meet with probation. You have 30 days to appeal. Thank you.
Last person that's listed as out of custody on the docket is Jason Walterman, 24 CF 1518. I do not see him in court.
They would ask for a KP.
I just looked at my notes, and mine says March 10th. So, but it says docket day, then it says March 10th, which would be the trial week. So I want to make sure to see if, would he have been given a piece of paper with his date? I want to make sure I didn't tell him the wrong time or the wrong date, and that's why he's not here. Because he was pretty insistent about having a trial, right?
Yes, Your Honor.
At least according to the clerk's minute sheet too, that the state's offer would not be extended after today. So that, this is what I'm going to do. I'm going to issue the capias, but once we finish up, I'm going to go listen to the recording, see if there was any talk about me giving him the wrong date. If there was, I'll withdraw the capias. Or if he shows up on, at this point, I think the state's going to be off the hook for the trial as far as going this time around since he's not here. But if he shows up on Friday, I'll withdraw the capias. If I told him something wrong, the way my notes are written, I would think I still told him the right thing, but I don't want to take any chances that someone gets arrested because I gave the wrong date. All right.
Ready?
Write myself a note on that really quickly. He's going to want to do that as soon as we're done.
Douglas.
All right, go ahead.
Douglas, 24 CF 1226, 24 CF 1678. We're going to ask to put this on for Thursday. We're attempting to work out something with the state. The state was unable to get to it, and she's going to try her best to get to it before Thursday.
I'm sorry, his name again? Joshua Douglas. I heard it 3 times, but it's out of the order that I was doing, so that's what I'm trying to. Yeah. All right, what are we asking for?
Your Honor, based on...
Sounds like there was another discussion. So.
Your Honor, based on the newest discussion from the state, we're going to ask to put this on for 4:30.
Without subpoenas today.
It was, yeah.
April 30th at 9 o'clock for your next pretrial, Mr. Douglas. See you back on April 30th. You're okay.
Your Honor, can we address briefly Mr. Samuel Roberts?
Okay.
He pled earlier. He just advised us he lives in Montgomery, Alabama. I just want the court to understand and him to understand he will have to pay the $100 transfer fee prior to.
Can you understand that, Mr. Roberts? You want to move here, right? Okay. Allow for the transfer.
Okay. Thank you.
Obviously, he'll explain the paperwork you have to go through, and the transfer fee is $100, just so you know. All right.
Your Honor, this is Brandon Dykes before the court on 21 CF 1811. CF 1909.
This case is 3.5 years old. What are we doing with the case? Rivers, I know it's new to you.
Yes, Your Honor. If I may approach from the statement.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Based on the issues discussed at the bench, it'll be April 30th, 9 o'clock. Obviously, if whoever is representing Mr. Dykes at that point is going to do any viewing of the evidence that has to be done at the lab, is the way it was referred to, then that needs to be done before that pretrial conference. This case is, again, 3.5 years old. All right, Mr. Dykes, we'll see you back at that point.
Thank you.
All right.
Thanks, Mr. Erders.
Your Honor, this is Gerald Parker. He's before the court on 24 CF 1300. We set this case for trial last time. However, Mr. Parker made asked to make a counteroffer of 6 months county jail. The state was going to check with the victim.
What number do you have him on the docket?
I have him as number 53.
Here he is. All right. Oh.
I believe the state's had the opportunity to make contact with the victim.
I had a Parker listed, but it's a different one for trial. It was Ms. Flowers' Parker case. I think it was the term.
See in the court minutes said without subs for this
Without?
case.
That's the
Yes,
one.
Ms. Glisson had indicated that she checked that it's
Okay.
without subs.
I just want to make sure, because I thought you said it was set for trial.
We thought it was.
No one else did.
Apparently no one else did.
All right, so there was a counteroffer.
We just need to reach out to the victim, Your Honor.
If we could try for Thursday, and if not,
Do we want to do Thursday or Friday?
whichever.
Thursday's fine.
All
Because
right.
we don't have subpoenas issued either way, so, but we could try for Thursday.
All right, we'll do Thursday, the 6th at 9:30. Mr. Parker, you'll be brought back to see if they can decide if they're going to accept the counteroffer.
So
Mr. Riggs. What number is that?
Your Honor, that would be number 56 on mine. That would be page 23. That's Colton Rigs, 24 CF 499, 24 CF 2212, 24 CF 2231. We are in discussions with the state. The issue has come up in drug court, whether in fact he can get in. Still haven't heard whether there's final approval. We want to put it on a
Another, has he been evaluated for inpatient treatment? Because that could be also an option.
Check.
But we
did. I thought we did, but he's thinking that they turned it down.
Oh, I understand. Move it, it's fine.
Early March.
I tried to, but it's hard to keep.
Early
Early
March.
Okay.
You want to put it last week?
How about we put it on for the regular 4:30, but if we can get something
Right,
down before
that's
then.
fine.
All right.
Could, Your Honor, put it on for 4:30, and if we can get him into drug court or some program prior to that, bring it to the court prior to that.
Mr. Riggs, it'll be April 30th at 9 o'clock, but obviously if they work something out, we'll bring in an earlier date to get it resolved.
Yes, sir. Thank you.
Thank you. 24 CF 2304.
Your Honor, this is Tony Tatum, as you indicated, 24 CF 2304. This matter is set for trial. I believe that Mr. Tatum has turned down the state's last offer.
Yeah, the last offer was to plead to a misdemeanor 4 times served, and I guess he didn't accept that. The victim is uncooperative, Your Honor. She's not. Yeah, she's not cooperative. She's not going to come to testify, so the state is going to dismiss the case.
Okay. All right. Case has been dismissed, Mr. Tatum.
Thank you.
Your Honor, I did have a lengthy discussion with Mr. Young, and gave him some material to read. I just need to touch base with him for a moment.
Yes.
Your Honor, Mr. Young has indicated that he does have a number of new questions to ask. I would just ask to put this on for Thursday or Friday.
I wrote that the last continuance was the last continuance. I was told this would be a plea.
Yes, Your Honor.
Want to put it on Thursday? All right. And what's the offer at this point?
Your Honor, it's 10 years DOC followed by 20 years probation.
Thursday at 9:30. What's wrong?
I had nothing in the morning.
Y'all want to put it in the afternoon? I'll be here the whole time. Everybody.
I'll be here when you tell me, Mr. Judge.
Okay.
If it's okay if we did Thursday, that'd be wonderful.
I mean, we can always call it a little bit later if you, it doesn't matter to me. All right, we'll say Thursday, the 6th at 9:30, but again, if y'all want to push it towards the end of the dock, it doesn't bother me any. All right.
Your Honor, I do have one other issue that is on the docket, and that is Daniel Wesson Reed.
What number is he? I saw it somewhere. Is that the one that was listed under like a different public defender? I hadn't
That's
heard
correct,
of?
Your Honor. That
Okay.
is correct. The PD2, an attorney from PD2 filed a motion to correct sentencing error,
Okay.
and that is what is before the court. Specifically, the probation cases where he was sentenced to more time. He was sentenced to 15 years, but cannot be sentenced to 15 years. Let's see. probation on November 4th, 2024. And sentenced him to 15 years in state prison on each count. See sentencing transcript, page 218, 219. And in case number 23 CF 1608, he pled to a third-degree felony originally. Therefore, he could not get 15 years. And in 23 CF 2429, it says he pled to 3 misdemeanors and 2 third-degree felonies. So it's the same problem. He can't get 15 years.
Oh, just got 15 years DOC, and there was no breakdown as to third-degree felonies or misdemeanors.
Correct.
Has the state had a chance to review it?
No, I guess that I have to concede the motion, Your Honor, because on the VOP, he's right. He was charged with third-degree felonies with a maximum 5 years. And so,
I mean, I wasn't there for it. I see there is a transcript. I mean, we can certainly correct it to make sure it goes the right way.
I don't have an objection.
Was it a plea or was it
It was
He was found guilty. He was found guilty
at trial?
at trial, and then he was found guilty of violation of probation.
That's 15 years on all counts. 3-year minimum mandatory in 24 CF 783. I don't think there's any objection. I mean, y'all normally do that order? Who does that? I can do it, I just don't want to do it if someone else is going to handle it. As far as the normal
Good
judgment.
order, but I know that we're not the ones that would do the corrected or amended judgment.
Usually, from my understanding, is I have to order them to do a corrected one, which is part of the order that if you could do that, Ms. Rivers, I mean, I certainly agree with it. You can't give 15 years on third-degree felonies or misdemeanors.
The only thing, Your Honor, Ms. Glisson just advised that the score sheet, the guideline, trumps the maximum for.
That's correct, and that is cited as number 4 here in the motion, saying that the lowest permissible sentence of 84.45 listed on the score sheet as being the lowest permissible sentence, and therefore it can exceed the maximum of 5 years. However, it can only be the 84.45 months. It cannot be 15 years.
And so instead of a third-degree felony, it being 5 years, it would be the 84 months.
Correct.
Everyone will agree with that?
Okay, yes, Your Honor.
Good catch. All right, and you're going to submit that order, Ms. Rivers? I just know there's a timeline. I know it's 60 days, and we're only a couple weeks into that, but just to make sure it gets to me before then.
I'll do it this week, Your Honor.
All right, thank you.
Mr. Nichols.
Yeah, 14.
Ms. Rivers?
Yes, Your Honor.
I've been magically informed that we will be handling that order.
Oh, okay, thank you.
This is the same one.
Can you raise your right hand? you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Tyler James Nichols, 7/23/87.
Just want to move the microphone and be fine. All right, Mr. Nichols, you're here in 24 CF 2166 and 24 CF 2528. Both are one count of possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison each. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would have you plead no contest as charged for an adjudication of guilt, 6 months county jail, credit for time served to be run concurrent or at the same time. 615 court costs, $150 PD fees. And again, each case concurrent, and this would be a downward departure, correct?
That's correct, Your Honor.
All right, but based on uncoerced plea bargain?
Yes, Your Honor.
All right, Mr. Nichols, is that what you want to do?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Not yet, sir.
Did not. Why don't we just have you quickly sign it? I know we just wrote this one up this morning, or this afternoon.
And there's no pass-through. I got everybody else's signature on it, but not you. All right, sir, let me get your signature right here. Mind if I date it for you?
I'd be glad if you did. Thank you, sir.
Mr. Nichols, do you understand that your guideline sentence was 17.025 months?
Yes, sir.
So that's the lowest I could have done short of the plea bargain for you.
Yes, sir.
Okay.
Thank you, sir.
Don't thank me. All right, and are you satisfied with Mr. Williams' representation?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Did anyone force pressure or threaten you to enter this plea?
No, sir.
Anyone promise you anything other than the downward departure sentence?
No, sir.
You understand if you enter a plea, there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which were listed on page 2 of your agreement?
Yes, sir.
Do you understand you're waiving all potential defenses?
Yes, sir.
Do you understand this would come with a driver's license suspension, correct?
The possession controlled substance, yes, sir.
Yes. So I'm not suspending your driver's license, but when DMV gets the copy of the conviction, they'll suspend your driver's license.
Yes, sir.
Court would not have an issue with a hardship license if you're otherwise eligible.
Thank you, sir.
All right. And your plea, sir?
No contest?
All right. I'll accept your no contest plea, adjudicate you guilty, 6 months county jail, time served, everything's concurrent, 615 court costs, $150 PD fee. And this is a downward departure based on uncoerced plea bargain. I'm gonna need your fingerprints, and you have 30 days to appeal. What do you wanna do about the, just 90 days to pay or else judgment?
Yes, sir.
All right, so you've got 90 days to pay your fees that I've just announced. Otherwise, it'll be sent to judgment. You can also set up a payment plan within those 90 days.
Okay, yes, sir.
90 days from your release. To make
Yes,
sure
sir.
it's clear.
Just go by the clerk's office.
All right, I'll pay it right away. We good? Yeah.
Yeah, just go over there, get fingerprints.
Evan Jones. What number's that? All right. I don't see Devin Jones. What number? 22. Oh, it was Dixie the Empire. I don't remember seeing the two Powell. What about Mills? Wasn't that set for trial? Objected to the
Your Honor, may we approach briefly?